Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Green buzz lights up the air, faces tense as stories tear, truth and lies like a tango dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes stand, shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Hello, good morning, everybody. Hi. Hello. I have got someone with me here today. That's why we kind of started. Oh, are you okay? Yeah, do you want to burp? Sorry. I was just feeding her. I haven't finished, but it's time to start the stream, so I had to quickly start. I'll play a video while I will burp Anya, but she's a guest of honor today. Yeah. So, you okay? Are you all right? Yes, you're gorgeous. Sorry. I know, babe, it's a girl. We have a girl in the stream today. I know it's a baby. She's gorgeous. She's the light of my life. She's absolutely gorgeous. Obviously, Garden Butt is also the light of my life. I still like him very much, but she definitely is something else. Um, yeah, and she's fed because she literally just had a bottle, which is great, but an happy change is due, and I can hear it right now. Oh, and the joys of you guys not having smell-o-vision. I love that. But good morning, everybody. Hi, Denise. Hi, Stephanie. Hi, Roba. Breda, welcome in. Hello, my friend. Zizi, I hope your day goes well. Today's gonna be probably a shortish stream. Yes, it is. The only thing I don't look sound very well is by the nappy that I'm about to change. But yes, good morning, Emily. How are you? I hope you are feeling better. Might have to turn off the camera a couple times today, obviously to take care of the baby, and I'll try not to have many gaps. But I thought that we could do a bit of a trial prep for next week for the Sadie Robinson homicide. We have a lot to catch up on this trial, but I think I might just put some hearings on at the moment, because I definitely can hear an happy change too. And as well, there is a hearing I want to watch at 11 a.m. Eastern of Rodney Hilton. Oh yeah, hoping like we'll keep you in our thoughts, Emily, for sure. Fingers crossed that is gonna be good news, and it's gonna be all good news, isn't it? And Anya, my niece over here, she's wishes that too for you, and I really hope that is very very good news for you, my friend. So I thought we could start at 11 a.m. I'll try to see if we can cover the Rodney Hilton hearing out of Cincinnati in Ohio. We're gonna do some information on Maxwell Anderson. So watch a couple of videos. I think there was a mini hearing in there as well. We can go through the timeline that there is of the trial, and probably will be it because there's no trial today. There's no Karen Reid today. But yeah, today probably because I've got the baby, it's not going to be as a long of a stream as we normally do. But I'm sure that that will be okay, and we'll hang on. We might do some parole hearings later. Actually, I do wanted to start with that because I need to focus and to talk about the Sadie Robinson's hearing. So I'm just going trying to see if there is either just Simpson is online or some parole hearings. I will have a look of what's going on. And my niece is looking at me very with a very dirty eye. She's like rolling her eyes. I know you thinking. I know, my lovely. We'll definitely find something. Definitely. Okay, there's no one at the moment online, but we can put something on while I do. not a nappy change, a diaper change. I know she's just hearing me talk and rumbling like normally, like I normally do. But yes, so I know you guys watched some hearings yesterday with our lovely Roba. So let's do a random parole hearing from another day. I know, girl. I know. Auntie Katia wants to pay attention to you, but that'll be just 1 second, okay? I just need to put something on. I know. Oh, are you sleepy? Oh, we do need a nap, do we? Oh my days, I have so many tabs open. That is insane. Um, but we definitely need to change. So first of all, we're just gonna hear some parole hearings while I am in the background, do some nappy change, and then I'll be right back, and then we can start doing the Maxwell Anderson digging into the case and then finding exactly what that case is about and more. So, oh,
Okay, good morning.
there you go.
Today's
I'll be right back.
4/24. The parole board is called to order. My name is Pete Freeman. I'll be acting chair. To my left is Mr. Tillis. To my right is Mr. Barros. Will be your panel today. Will staff at headquarters please introduce yourself?
How you doing? My name is.
Wait up, I'm gonna get to y'all.
Yeah, no, talk to the other people.
Okay, all right. Would the staff at Bossier Parish please introduce yourself?
Yes, sir. Deputy Adam Edwards. I'm a classification officer here, and I got Miss Jessica Brazil from the Tri-Share program here.
Miss Brazil. Okay, we're gonna let Miss Brazil talk at the proper time. Okay, let me put a little information in the record. You are a first-class offender. Your parole eligibility date is 11/25/25, and your full-term date is 5/25/27. You're serving a 6-year sentence for second-degree rape and domestic abuse battery. Does that sound correct?
Yes, sir, Your Honor.
Okay. Mr. Wade, we're gonna talk to you first. Tell us what got you in this place, in the predicament you're in now, what got you put in jail, and why you think we should look at you for early release, for parole.
Well, what got me here was I was married. I'm married. I've been married for 30 years. I moved out. I got an apartment during the pandemic, and I met this girl. So after the pandemic, we moved in, and we moved in because she lost the house, and she was like $2,500 behind on the taxes. So they put a lien on the house. I paid the lien. I moved in like maybe 2 months later after my lease was up, and I started giving her like about $800 a month. And once she got the deed back, let's say she got the deed back like 2 months later, and I found out that she was on drugs. And one night, I didn't want to give her no money. I kept her safe in the house. I did transmission work. And one night, I didn't want to give her a few dollars. And she started acting all crazy because she'd been drinking. I gave her like $100 when I came home that day, but it was like 2 o'clock in the morning. And she left out the door. And when she came back, she started ramming up the side of the house. She had the truck parked outside the door, kicking the side door in. So I'm on the phone with her aunt. So I'm like telling her aunt I'm about to just pack up and leave. And she was like, well, call me when you get somewhere safe. So about 3 o'clock in the morning, she was like, don't leave. I'm like, well, I gotta leave because I can't keep living like this. You know, I never been in jail before. I did been in jail for some tickets. And I found out a bag of marijuana was like 20 years, when I was like 20, maybe 29 years old.
Mm-hmm.
So the night went on, when the sun started coming up, she kept asking me what time it is. I'm like, I don't know. I said, look like the sun coming up though, and I have to get to the shop in the morning. And I gotta meet Derek at his house to go pick a car up. So I dozed off. let's say about 8:30, I dozed off for only like an hour. When I woke up, she was gone. So I got to thinking, I said, oh Lord, I said, she up to something because she never just leave. So when she left, I immediately got up, I grabbed the safe, and I grabbed my kid's motorbike, and I took it to her mom's house. And I went on about my day, went to the customer's house, picked the car up, came back to the house, and checking on her to see what's going on. And when I went back outside, the license plate was gone off the car. So I'm like, I said, something is up. I said, that's odd. I said, well, somebody take the license plate off the customer's car. So when I jumped back in the car, I was surrounded by detectives saying that I strangled her and raped her. So I'm like, strangled her and raped who? Krishan. I was like, that's my girlfriend. We live together. So like, well, she said you strangled her and raped her. I'm like, I never touched her. But they said that when they put me in jail, they said that I was flight risk. So a flight risk because I had some traffic tickets that I never paid. So, okay. So they gave me a bond, maybe $500,000. So I got to pay a lawyer and he quit during pretrial. So they gave me another lawyer. And she just kept telling me if I didn't take the plea deal that I'll be going to jail for the rest of my life. And all she got to do is get on the stand and cry. So I'm like, but I never touched her. And he was like, well, I said, the detective was like, she don't have a mark on her. I said, well, what about the rape kit? They said they didn't need a rape kit. They just need her to testify to say that I had sex with her and I raped her and that was it. So I kind of like put myself
Y'all have sex that night? Did y'all have sex that night?
We had sex the day before, but we had sex all the time, but we didn't have sex that particular night.
Okay. All right. Your case has been assigned. Well, first off, in opposition, we have Mr. Randall Myers. First, let's hear from the lady from the treatment center, Ms. Brazil. Ms. Brazil, what do you have to tell us about Mr. Wade?
Good morning. Mr. Wade has been doing substance abuse and sex offender treatment with us. He started treatment on August the 1st, and he has a projected graduation date of July the 25th. With his sex offender treatment, he has passed phase 1 of the Louisiana risk management model for sex offenders, and he'll be eligible to take his phase 2 test in May. So, and then once classes, when he gets to the last 3 months of classes, he'll be able to take anger management or DV or anything like that that may be appropriate for him.
Okay. And he's not giving you no problems?
He is not. He has had 6 positive behavior reports for his participation in groups. He hasn't had any write-ups. And the counselors are saying that he participates in treatment.
Okay, thank you, ma'am. Appreciate it. Okay, next we're going to go to Mr. Randall Myers from the DA's office in Jefferson. Mr. Myers?
Yes, sir. Randall Myers, Assistant DA, Jefferson Parish. We're opposed to his request for parole. There's victim opposition. In reviewing the record, there is evidence of bruising, and physical injuries to the victim after this incident. Until he is completed with all of the programming that he should be taking, particularly the sex offender treatment, and I think he's still in substance abuse, that he's not completed those programs. Till he's completed those programs, I think he should not be considered for parole. Thanks.
Thank you, Mr. Myers. Okay, your case has been assigned to Mr. Barra. Mr. Barra, would you lead us in question?
Yeah, my question, I think you answered it, but I want you to elaborate on it a little bit. You said you pled guilty, but you're innocent of the charge. Is that what you said?
That's pretty much what I'm saying, because she kept telling me that if I didn't plead guilty, that I could take it to trial. But I was looking for a physical rape kit. And when the detective went to court, he told the judge that there wasn't a mark on it, but the judge said that she didn't have to have a mark on it. So I don't understand why he's saying there was marks on it, because the detective was in court. And when the paperwork came back from the doctor, I was asking, what does this mean? The paperwork kept saying everything denied in my what you call it, the discovery packet. She was saying that, well, that's just a report that the doctor gives. So I don't understand where the marks come from, what marks. And as far as me pleading guilty, I didn't want to take the chance on being in jail for the rest of my life or losing my parents while I'm in jail. So I just took the 6 years. And the judge said that if I didn't take the 6 years, that it would be significantly higher. And he didn't know why it was so low to begin with.
You know that the guilty plea, I'm sure they explained it to you. Once you plead guilty, you're saying, I did the charge, I accept it, I am guilty.
I did understand.
So, and yet basically you said that so that you could get the 6-year deal.
Yes, sir.
Okay. That was my only question.
Hi, Quincy. Mr. Wade,
Yes, sir.
do drugs?
Well, I did drugs, but I went to rehab and I want to say I went to rehab in like 2012.
Were you doing drugs the night all this happened?
I probably smoked some marijuana. I wasn't doing drugs.
Okay. So you didn't rape her. You're saying
No.
you did.
No, sir.
How long you been incarcerated?
Going on 4 years.
And this your first offense?
Yes, sir.
Okay, all right, thank you.
Okay, so I know she even states that she had been drinking all day. So you were a little high and she was a little drunk. There was physical contact?
She was drinking and and when she came back to the house, she came to the back door. She rammed the back door down. And when I opened the door, boom, she had a mall hammer in her hand. And I grabbed her. And that's all I did. I grabbed her. And I threw the mall hammer. I took the mall hammer and I threw it behind the door. And that was the only contact we had. Now, as far as her having marks on her arms, I told the detective, I said, well, those green lawn chairs that's sitting on that floor, she was taking those lawn chairs, ramming the back door with it. And when they took the pictures, they saw that the door frame broken. So that's how she got the marks on her arms. I didn't grab her and make any marks on her.
Did you, when she was taking a shower, did you go in there and start arguing again?
Never touched her.
Okay, I have no further questions. Mr. Barra?
I'd like to go into executive session.
I have a motion for executive session. Do I have a second?
Second.
Okay, we have a motion and a second. Please call the roll.
Mr. Tillis,
Yes.
Mr. Freeman,
Yes.
Mr. Barra,
Yes.
Okay, we're gonna go into executive session for a few minutes to discuss confidential matters. We'll be right back.
Okay.
All right, so let's skip this one. Sorry, I'm nearly finished. I have absolutely no idea what's going on, but I think we are okay for now to maybe start talking about our case. Oh, no parole for him. Yeah, probably no parole for him because I don't know what he did, but probably was something very bad, wasn't it, Anya? It was something bad. So, situation is under control. Oh, sorry, I can go on. Situation is under control. We have a new outfit on. It might be a little bit big for her, but that's all I had over here for her. But I think she's ready for her nap of the afternoon. One more, because she hasn't had enough. Have you? You haven't had enough, have you, my beautiful girl? Sorry, I'm absolutely a wreck. There was an explosion everywhere. You don't need the details, I'm sure. So what I thought we could listen first, because this case of the Sadie Robinson run is one that Stephanie, our friend in church, is going to be attending to next week. Well, it is supposed to start next week, but we still have jury selection first to go through, and then the trial can start if there is no other stuff going on at the same time. So, oh, are you serious? Oh wow, there was a small plane crash into a San Diego neighborhood. Ugh, that is not good. Sorry, just was looking at that. So our thoughts that first of all we could listen to was a preliminary hearing of this case, because I think it might give a little bit of an insight, and that's where we could start talking about this case of the Maxwell Anderson case. Yeah, exactly. That's the thing. That's what I thought. Yeah, the jury selection would be a little bit harder, because people know about this case. The case has been really out there. The family's been really outspoken about, and everything. So it might be a little bit tough. So it might take a hot minute to get. So this is one of the. Oh, sorry. Did I scare you there? One of the many videos that we're going to be listening to today. This one is a rather short one. It's about 4 minutes, but we can start from somewhere, and then maybe we can talk about like a timeline, and this one. So yeah, probably, yeah. Because it was a horrendous case, because it happened on April 2nd. 2024, so not that long ago. So then we can talk about the timeline, go exactly what is going through, like some messages that they have had apart from the court records and everything, and then just do that. But Miss Annie needs a bit of attention, so I'll be playing this one and I'll be right back. I'm sorry, guys.
State of Wisconsin versus Maxwell Anderson, 24 CF 1692. Count 1, first degree intentional homicide. Count 2, mutilating a corpse. Count 3, arson of property other than building. This case is assigned to Judge Kai's branch 45. Appearances.
Ian Vance Curzan for the state.
Good afternoon, Your Honor. Attorney Anthony Cotton with Maxwell Anderson. He's here in person.
Good afternoon.
Commissioner, to start, I filed an amended criminal complaint. The purpose of that amended criminal complaint was to essentially include a footnote regarding the blood recovered in the residence. The footnote is on page 6, and it just indicates that the preliminary DNA analysis supports the conclusion that there is no support for inclusion of Robinson's DNA in the blood or swabs that have been tested. And in some of those, her DNA has been excluded. But I just wanted to clarify that because it was brought up at the initial appearance. So that's why I included that. Otherwise, I think there was just a couple Scribner's errors that were corrected. And the rest of the information remains unchanged. And there's no additional charges.
But I did have noticed that an amended complaint was filed. Any objections to probable cause?
Not at this time.
All right, I have read the criminal complaint. It does state probable cause. Waive reading?
We do.
All right. I'm showing you a document that's called preliminary hearing, questionnaire, and waiver. Is that your signature near the bottom of this page?
Yes, Your Honor.
Did you read this document, or did your attorney read it to you, or both?
Both, Your Honor.
And did you understand it?
Yes, Your Honor.
Did you understand that if you had a hearing, the state would have to produce witnesses and perhaps other evidence to show that you probably committed a felony?
Yes, Your Honor.
Did you also understand that by waiving that hearing, you are conceding that the state can establish probable cause and you will be ordered to stand trial?
Yes, Your Honor.
Anyone make any threats to get you to give up your hearing?
No, Your Honor.
Anyone make any promises to get you to give up your hearing?
No, Your Honor.
I will find that Mr. Anderson has made a knowing, intelligent, and voluntary waiver of his right to have a hearing and order him bound over for trial. I'm also in receipt of a request for substitution of judge against the Honorable Gene Keyes. That is approved.
I filed a signed and dated information today. I sent a copy of that document to defense counsel prior to the hearing.
Acknowledge receipt, enter not guilty plea subject to our substitution request. Thank you.
This case will be reassigned to Judge Sanders, branch 28. I can do this with May 13th.
I'm there Thursday afternoon, the 16th.
Okay, let's take that.
Next court date will be May 16th at 1:30 for a scheduling conference in branch 28.
Thank you.
Thank you. Have a good day, Your Honor.
You too.
See ya. Have a good one.
Out anything else, then I'll have them brought out. Please rise.
Sorry about that. Busy with the baby. It's gonna be a busy afternoon. Sorry. But that was the Jesse Kurczewski trial, the one that I keep talking. That was also from Milwaukee. That was given on that one. But hi, good morning, William. So we are currently going through some of the videos on the Maxwell Anderson trial. Sorry, the baby's a little bit unsettled, so that's why I was away from the computer and trying to do both things at the same time. So it's I did not hear it. I'm gonna have to go through it again. It's okay, Anya. It's all right, baby. Are you okay? Yeah, I think she's falling asleep. Right. So okay, maybe now we can go through the timeline of the events, to exactly to what happened in this whole case, the timeline, when it started and when it did not start. So I'm going to share a news article that got sent and was shared with me on our Facebook group, and that exactly talks about exactly what happened. So on the day before because everything happened on the day, April 2nd, on April 1st, to understand exactly what happened, we need to go back to the day before April 1st. So court records show that text messages between Robinson and Anderson, so that's Sadie Robinson and Maxwell Anderson, the defendant, was between 4:15 p.m. and 5:18 p.m. Anderson texted, "Are you hungry? I need to stop at Twisted Fisherman to pick up my W-2 from last year and we could eat there first." So because Anderson, from what I understand, Anderson and Sadie, they were going on their first date. So they were trying to arrange things. Robbins replies, "Okay, and yes, are we eating at the Brad house or at the other place?" Anderson replied, "Let's eat at Twisted. I'm feeling seafood." Robinson says, "Yes, I love seafood." So then you can see the proper messages between them two in a text format type thing. So then still images from surveillance cameras show that the two inside of the Twisted Fisherman. Investigators says that Robinson had a Life 360, a location tracking app. It placed her at Duke's on Water and later at Anderson's Milwaukee home, which has been sold, near 39th and Oklahoma. Is it the first place Sadie's loved ones believe she was the last place that Sadie's loved ones believe she was last seen alive? Because her phone pinging at his home until 1:45 a.m. on April 2nd. So then her cousin actually has been very well spoken about this whole case. Did to try more videos. I saw a video of her cousin. I hope I have it on my mountain of videos, which probably we can play a video right now about that. So let's grab this one, and then go this. We can come back to this and just hear a little bit more.
Filled with pink balloons, people leaning on each other after a gruesome discovery following a woman's death.
19-year-old Sade Robinson died earlier this month. Investigators say a man killed, then dismembered her after their first date. 12 News' Emily Polfall reports on a vigil tonight in Kilbourne Reservoir Park, which is close to Robinson's home.
Let's celebrate the life of Sade Robinson.
Sade Robinson, described by the people who loved her most.
Anybody who knew Sade knew that she was different from everybody else. She went through a lot even before she died. She never let it go break her. She was the strongest person I know.
She was my best friend. I will miss her. We had so much happiness and fun together.
Between the tears and memories shared, a resounding plea.
Justice for Sade!
Justice for Sade!
The bright, loving 19-year-old murdered just 1 month before she was supposed to graduate college.
We are tired. Yes. We are sick. Yes. This is not okay.
But this is very, very tough for me and my family. And it's going to be tremendously hard to move on living.
But they aren't doing it alone. Dozens from the community, many strangers, showed up to a vigil Friday to support Robinson's grieving family.
She brought us, care for her family brought us here. I think this is a terrible theft for the city. I think this man stole her. He had no right to do that.
An unimaginable loss and a story resonating with so many.
Justice for Sade!
Justice for Sade!
Emily joins us live now from Kilbourne Reservoir Park. Emily, people there say that.
So, and then I think that's why Stephanie and I think many others says that it's going to be hard to be founding a jury in the first couple of days, because this has been a very, very big trial there. Oh wow, that is crazy. Oh, that is absolutely crazy. The journeys to justice. Good morning. Yeah, the balloon thing is something rather interesting. So then just the the Nancy Grace actually spoke to the mother of Sadie, so which was a very, very heartbreaking thing. But we could watch a hearing that Anderson had about 5 months ago. So was scheduled a hearing, and because I think at the time they wanted to delay the trial, so thought we probably could watch this next and then talk about. Oh, really? It does? Oh, I did not know that. That is crazy. Ugh.
Parties all set to go on the record?
Yeah, we're ready. Yes.
Calling State of Wisconsin versus Maxwell Anderson, case 24, CF1692, appearances.
DDA Megan Newport and ADA Ian Vance Curzan for the state of Wisconsin. Good afternoon. Good afternoon, Judge. Maxwell Anderson appears in person with attorneys Anthony Cotton and Jason Findling.
Good afternoon. We are here for status. And the and the defense has filed a motion to adjourn. We did discuss this off the record, but is there a record you'd like to make, Attorney Cotton?
Thank you, Judge. We discussed it earlier this morning, as Your Honor noted, and much of the arguments in the motion, I think, are self-explanatory. Basically, the issue is one involving an expert witness, as we explained to the court. This is a complicated case with a lot of discovery and a lot of material. Information from the state has been transmitted basically throughout the months that we've been handling this case. At some point during that process, there was Mr. Anderson's devices were seized, his Dell desktop computer, his cell phone, in a search warrant was granted for those devices. I'm certainly not a tech expert, but as I understand the process, the warrants that were secured in this case permitted law enforcement to conduct a partial examination of those materials. And I believe a 30-day extraction was performed, at least that's the way I understand it, that was obtained, was turned over to the defense at some point in this process. And what we learned was that Mr. Anderson was alleged to have, of course, he is, as you know, the last person who was with Sade Robinson before she went missing. We learned that there were photographs allegedly in his phone that had been deleted. When we became aware of that information, we hired a friend. Well, we first had to go to the family to discuss our desire to hire a forensic expert because we're privately retained on this case. And so we met with the family. We conducted a broad search for an expert who would have a lab who could actually examine the materials. There are, of course, experts locally that we've used in lesser types of cases who can go to the police department and review materials on like child porn cases, for example. There's experts who can go to the police department to look at a device. What we needed in this case was a company that had a lab that could examine the raw data itself to help us answer some questions. There were actually a few other questions we had based on our review of the initial report that was provided by the state. When we hired our expert, normally, if there is a normal in this case, but normally what happens, as I understand it with this expert, is material gets transmitted electronically. So a lot of times you get a link from the state, you send it over to the expert. And Mr. Vance Curzan can confirm this, but what has had to happen here in this case has been just because of the quantity of the material, in other words, the size of it, we've had to purchase multiple hard drives, deliver them to the DA's office, have the material copied onto there, and then have those drives shipped to Florida. We've had to do that twice. And this is not a request I make lightly because we've kept weeks set aside for this trial, as has the court, as has the state, as has everybody. And I have to just make the decision to either make the request or not. But to do my job properly, I have to make the request to adjourn the trial. Our expert will not be done with his report or his review by the trial date. He needs another month or so. Now, as I explained in chambers, where we're at in this process is the day before Thanksgiving, Mr. Vance Curzan provided us with a full forensic copy of Mr. Anderson's phone. As we understand it, the Dell desktop computer isn't particularly relevant in this case as we understand it. But our expert needs a full copy of the forensic analysis of the forensic copy of the phone. So we provided a hard drive. We were given that forthwith, picked it up on Wednesday, overnighted it that same night down to Florida for the expert to review. As of yesterday evening, he didn't have the materials yet. We were checking with him basically every day. And then today he now has it, or his company has it. He needs that and needs to review that in order to be able to finalize his report. The reason why the report is significant without putting every fact on the record is because it potentially is an alibi. Insofar as, and it's not a formal alibi where we would have another person who would say they were with Mr. Anderson when the victim was missing, when Sade went missing. But our expert believes that there's evidence on Mr. Anderson's phone that suggests that he was using the internet, presumably at his home, during the time frame that another person would have been driving Miss Robinson's car around. So we've asked him to finalize that report. He did provide a draft report. I don't believe I have any discovery obligation to turn over a draft report. Frankly, I don't think I do, but I turned it over right away because I just wanted there to be transparency here with what we were striving to have done, which was to have this report finalized, hopefully before trial, to move it along. But there's a balancing act between moving it along and doing it right, and I need to do it right. So I got the materials to the expert. I've given a copy of the draft report to the state. My expert tells me that he will have his review done, and I have no reason to believe it wouldn't be done within the next 30 days or frankly a couple of weeks. The state's expert, Juan Luis Villegas, who's with DCI, is also based on the draft report rebutting that. What I'm going to do, or what I think would make the most sense, they're going to have their report to me by Wednesday, we think. So that will be transmitted, as I think what we're all doing here is transmitting each other's material so that the experts can have everything they have. And we'll go from there. If my expert is going to be helpful in light of what the state's analyst rebuts, he would be available for the dates that we had tentatively looked at, which was that last week of May, early part of June. Those we did ask, Your Honor asked us to check, we checked. Those dates would work with our expert.
State, any record you'd like to make?
Yes, I'd just like to add a few things to provide some context. After Mr. Anderson was arrested on April 4th, his Samsung phone was seized from him. Law enforcement obtained a search warrant to search that phone. The parameters of the search warrant only allowed law enforcement to access 1 month worth of material on the phone, specifically the dates of March 4th to April 4th of 2024. In order to comply with the search warrant, the parameters of the search warrant, the process that needs to be taken is that a full, what's called a forensic image of the phone is taken. It's basically a copy of the phone. And then the software can parse out the 1 month that allows us to be in compliance with the search warrant. And that's what's taken from the forensic image. And that's what law enforcement reviews. That's what's sent to me. That's what's sent to defense. And then in turn, that's what defense sends to their forensic expert in Florida. The state's contention has always been that Maxwell Anderson was left the house around 12:45 with Sade's car and her body and was driving around town throughout the night. It appears that the defense in this case is going to be an alibi that he was at home, something that came to light at our last hearing in court that was not known to me prior to that time. And they don't, unless it's an alibi, I need to get notice of it, right? So I now know that that's what they're going for. And then when I got the draft report from the defense expert the following Monday, seemed to suggest the same. But then I was made aware that in order for the defense expert to do a complete examination that they want to do, they need the full forensic image. So I discussed with Attorney Cotton that it requires us to provide him with something that we're not even allowed to have or look at. And we had that discussion. It was ultimately, the decision was made, I think, by the defense through consult with their expert that they did want the full forensic image, and that request was made of me finally on Wednesday of last week, and I actually had DCI copy that for them before we could even look at it or have it. So that was provided. So that's the context with regard to the forensic image that the defense needs to now look at in order to investigate this claim that the defendant was home all night, which of course we don't agree with. So the state is ready to proceed to trial on December 9th. The state would object to an adjournment, understanding the record that defense has made and the job that they're doing. There's been a lot of preparation put into getting ready for trial. Defense is correct. There's been constant new discovery's been turned over as soon as the state has received it. The phone extraction was turned over a long time ago. The tower information that the defense mentions in their filing has been turned over a long time ago. None of that was a secret, and it's never been a secret where we've alleged that Maxwell Anderson was that night. So that's my concern with the lateness in the request. I understand where the defense is coming from to a degree, but we're ready for trial on December 9th.
Understood. So the defense is entitled to present their defense at trial. This is the first time the matter has been set for trial. In the defendant's motion to adjourn, in the 10 points that are set forth, it does go into detail as to why the defense is seeking this adjournment, which has been reflected here on the record, as well as the fact that there's been ongoing discovery received. It is a case involving multiple jurisdictions. I do understand that the amount of discovery is immense. I know that as of last week, we were still discussing turning over reports from both sides. At this point in time, due to this being the first time it's scheduled for trial, and in order to allow the defense to prepare properly for trial, I do want to secure the record. I do not want to create any type of issue on appeal. I am going to grant the defense's motion to adjourn. This morning, as I asked the parties to meet with their experts and to see whether or not the dates preliminarily obtained would work. Would they work for the state?
So far, yes. If I were to hear differently, it should be within the next couple days, and I'll notify the court and defense immediately.
Okay. So upon granting the motion to adjourn, are there any other issues we need to address today?
No.
Okay, we did finalize the jury questionnaire. I did add one more question to that, other than what the parties had agreed upon. That was the final question, which is basically amounting to, is there any reason that you can think of that as to why you could not be fair and impartial? Please list it here, just a catch-all at the end, but review that again. And then we'll recalendar the matter for final pretrial and trial. Would the parties like an interim date before the final pretrial for any reason, just to make sure that the reports are on track, or anything else?
I don't think it would hurt.
No, it doesn't hurt. That's a good idea.
Okay, we'll calendar it for that.
Okay, going off the record. With that being said, I'm looking at the week of February 3rd or February 10th for the scheduling conference.
I'm good 10 through the 12th, the 10th, 11th, or 12th, if that's available. I can just do that.
Okay. Yeah. Just give me 1 second. Did you have a preference?
10th is good if that works.
10th is fine.
8:30 or 1:30?
8:30 is good for me.
That's fine.
Going back on the record, the next court date will be calendared for February 10th at 8:30 for the scheduling conference. The final pretrial set for April 18th at 8:30, along with the jury trial set for May 27th, first call at 9.
Okay, we'll see you back at that time. Thank you, everyone.
So this, Nancy, it was the hearing before they pushed the trial for now. So this was after this hearing, there was another hearing that the trial was pushed. So that's why. But we're trying to catch up on everything, just so we know what's going on, and we're trying, because there's several other hearings happening today. Christopher Shore, the prosecution of the trial that we watch of Patrick Loyola out of remind me again, Michigan. Yeah, Michigan. They are gonna get a decision today, new charging decision, which they might have been lowering the charge on that case. I don't know. So it's gonna be happening in about an hour and a half. And then just before that, there was another hearing for Rodney Hilton, which I want to catch as well. So there is a lot. Oh, sorry, wrong one. There's a lot going on, but also I want to do a bit some information of this trial while we wait for all of that stuff. So yeah, the trial got delayed because of the defense. Supposedly Anderson does have the cell data, placing him somewhere else, which I'll see. Well, exactly. And that's why, like, there is a trial. Like, for example, I did a video today on Brian Kohlberger, the 40-page document that Ann Taylor released a couple days ago, and there was a lot of speculation, and that's why we need a trial to know exactly what's going on and what information there is, and then we can make our own decisions and go from that. Yeah, Celebrite. Yeah, Celebrite. That's fine. Yeah, that's okay. So now we watched that one. There is another video from now Court TV that says that police say that Shady's Robinson's blood was not in Maxwell's house, so it's a longer one. They might have, Court TV style, so probably we'll watch that one because I need to look after baby because she's a little bit unsettled and I need to make sure she has her nap. Otherwise, she's gonna be very grumpy to her parents later, and I don't want that because her parents will unalive me. So let's hear this one.
I was getting stuff out of the backseat of my car, and suddenly he was there, and he had a paintball gun, and he was okay. And
where it starts. Hang on. All right.
Go for the cases we're covering at trial and the ones that just have us talking in the world of true crime. So right now, why don't you go ahead and grab that cup of coffee because it's time for my opening statement. Whose blood is it? Whose blood was left on the bedding and on the walls leading to the basement in Maxwell Anderson's home? That's the question investigators at the Milwaukee Sheriff's Department are trying to answer this morning. Prosecutors say that lab testing on the blood showed them that it doesn't belong to Sade Robinson. So what does this mean for the case? In my opinion, I'll tell you, my friends, it doesn't diminish the murder case against that guy one bit. Let's remember, not all murders, rather, is what I want to say. Not all murders are bloody, right? Think about it. We see this all the time on Court TV. People can be strangled to death. People can be suffocated to death, and blood wouldn't be found at a location where the murder happened, right? Also, the dismemberment could have occurred near where her remains were found. It didn't necessarily have to happen at the house. Let's bear that in mind if he did what police say he did. I read through that criminal complaint thoroughly. The case against Maxwell Anderson is very strong. Police have video evidence of him, cell phone evidence of him, eyewitnesses who saw him. They have all of this information to prove that he is the guy who murdered beautiful Sade Robinson. And then they say he dismembered her and set fire to her car to cover it up. So now the question really becomes this morning, do investigators think the blood that doesn't belong to Sade is evidence of a crime against somebody else? Where will that blood lead them? I mean, let's think about it. Who lives in a house with blood on the walls? Really? Who does that? How did it get there? And what I really want to know is what is down in that guy's basement? Because I've read some local reporting that this guy had a sex dungeon in his basement. Police have not publicly confirmed that, but it certainly makes me wonder. I'm sure it does you too. I hope and pray that if there were other people harmed in.
Right, hang on. Oh, what? Oh, wow. Yeah, this case is gonna about be wild. Oh, dear me. It's gonna be. We are 3 minutes in out of the 44-minute video, and I'm already pausing it. This is gonna be a wild case. Oof. So then, like, the question that she has underneath is like, if it is not the victim charged, who is it? Whose blood is it? Another victim?
In that home, that police will be able to solve their cases too, just as I believe they have already solved Sade Robinson's murder. May she get justice the justice that she deserves, and may her family find some bit of comfort in knowing how many people care about Sade Robinson and about seeing her killer punished to the fullest extent of the law. That's my opening statement on this Wednesday morning. Let me know if you like it. Right now, I want to give you what's on your daily docket.
And you were indicted by greater. Okay, you're aware he's beaten up.
Oh, that was for something else, but that is absolutely crazy. Where does she starts talking about it? Because I don't want to listen to the whole thing. Because it has more that's in Peterson's case. This is was like what sometimes annoys me about the by court TV is that they start talking about one thing but then they just go on completely something else, and I just want to hear about one case, court TV. So I think we're gonna have to circle back to this one when I have a bit more time to focus, because now even though baby's asleep, I still need to keep an eye on it. But this is a very horrible case. There is another one that about body parts being found. It's a conference, so let's listen to that one. Hang on. Wow, this is absolutely wild.
All right, we ready? No. No? All right. Not that we're counting or anything, no pressure. Until y'all are done with your primary remarks, unless you want to tell them at that point, we can take a few questions, just a few. All right.
Yeah, how am I supposed to do that?
I could have practiced.
Going, Phil?
Here with, morning folks, I'm James Burnett, spokesman for the Milwaukee County Sheriff's Office. I am here with Milwaukee County Sheriff Danita Ball, Milwaukee Police Chief Jeffrey Norman. A little bit of housekeeping really quickly. You probably know this. If you don't, you probably should not be here. Sheriff Ball, DENITA BALL. Chief Norman, JEFFREYNORMAN. We good? Great. Okay, so we're here for a briefing on the an ongoing investigation for human remains that were discovered early last week, and again, all the subsequent information that has come after that. I have to tell you, this briefing may be brief because there are a number of questions we may not be able to answer. That said, Sheriff Ball, Chief Norman will give you what they can, and on that, I will hand it off to the sheriff.
Thank you. Good morning. Thank you for being here. Today, we're going to give a brief update regarding the severed leg that was found and some of the human remains that have been found throughout Milwaukee County. As you know, on April the 2nd, at approximately 5:29 p.m., Milwaukee County 911 dispatch received a call from Cudahy Police Department regarding a severed leg at Warnemont Park. It was near the golf course and the pumping house. And so the leg was amputated from the around the hip down. And as a result, the leg appeared to be that of an African-American female. Subsequently, a Milwaukee police officer who was aware of our investigation raised the possibility that the leg may be related to a missing person investigation that they were conducting, and that missing person was Sade Robinson. So on Wednesday, April the 4th, our investigation led to a person of interest Maxwell Stephen Anderson, who lives in the 3100 block of South 39th Street, where he was arrested after a traffic stop near the home. A search warrant was conducted. The severed leg has been preliminarily identified as belonging to Ms. Robinson. Our thoughts and prayers go out to the Robinson family, friends, and the Milwaukee community who have embraced this family. We are sorry for your loss. It's such a tragic incident. Our investigators have worked around the clock on this investigation. As a result of their diligence and with the help of our criminal justice partners, the District Attorney's Office issued charges today against Maxwell Stephen Anderson for first-degree intentional homicide, mutilating a corpse, and arson of property other than building. He remains in custody. The Milwaukee County Sheriff's Office would like to thank all of our partners involved in this investigation, specifically the Milwaukee Police Department, the Cudahy Police Department, the Kenosha Police Department, the Madison Police Department K-9 Unit, Great Lakes Search and Rescue K-9 Unit, the FBI, the ATF, the Department of Justice's Division of Criminal Investigation and their crime lab, the Medical Examiner's Office, the District Attorney's Office, the Milwaukee County Transit System, Wisconsin Southern Railroad, the United States Coast Guard, forensic anthropologist Gordon Karsten, and other partners who may have helped in this endeavor. Your help was very invaluable. Again, we extend our sincere condolences to the Robinson family as they navigate this difficult time and mourn the loss of Sade. I'm going to turn it over to Chief Norman, who's going to talk about other parts of the investigation. Thank you.
Thank you, Sheriff Ball. First and foremost, on behalf of the Milwaukee Police Department, our hearts and prayers go out to the family of Sade Robinson. This is a horrendous tragedy, and above all else, we cannot imagine the pain that you must be going through. Please know that you have our deepest thoughts and condolences. Details of some of the Milwaukee Police Department's involvement can be found in the criminal complaint that was filed by the District Attorney this morning. What we can share at this time is this. On April 2nd, Milwaukee Police Department investigated an arson at the 2800 block of West Lisbon Avenue. Video surveillance recovered from the arson investigation led investigators to search the area of 3000 West Galena Street. On Friday, April 5th, investigators located human remains in the area. On Saturday, April 6th, MPD continued the search in the area and located additional human remains on the railroad tracks. Later in the evening on Saturday, April 6th, MPD returned to the area when Ms. Robinson's family located her blanket. At this time, detectives located additional human remains. The identification of the human remains recovered by MPD are still pending. I repeat that. The additional human remains is still being looked at, and the investigation is pending in regards to the identification of that. Please note, we continue to search for additional evidence that has not been located. Anyone with information is asked to contact Milwaukee Police Department at 414-935-7360, or to remain anonymous, contact Crime Stoppers at 414-224-TIPS, or P3-TIPS. We're grateful for the efforts of the Sheriff Department, the District Attorney's Office, and other federal and local law enforcement partners for their tireless efforts to gather facts and evidence in this case. Please remember, this is an ongoing investigation, and as information becomes available, we will do so in sharing it. And we also ask to please remember to respect the privacy of the family at this time and allow them to grieve. At this time, I'll turn it back over to Sheriff Ball.
So if you have some questions that we can answer, you can ask them now.
Just to clarify, so the severed leg has been confirmed connected to Robinson, but not the human remains found Friday, Saturday, and Sunday by the Milwaukee Police Department.
A preliminary investigation have shown that the leg is Ms. Robinson's, and yes, the human remains have not been identified yet.
Are you looking into other missing women and reviewing those cases to possibly connect it to this case?
This is an ongoing case, and we have looked at other parts of the investigation to see if there are any others that could be linked. And so far, there hasn't been any evidence that there is any other victims.
Are you concerned that there could be other victims?
There hasn't been anything that is pointing to that right now.
Prosecutors are saying that this happened from the time that the two went back to Anderson's house, according to the criminal complaint, until the time that he pinged to Warnemont Park, which is a pretty wide time frame. Do we know when this killing happened and where it happened? Was it at the home? Was it in the car? Was it at the park? I'm a little unclear on that portion of the criminal complaint.
We can't, it's still part of the ongoing investigation, so we can't comment on that.
Do you know how she died?
Can't comment on that.
Or do we know how they met, the suspect and the victim?
It's my understanding that they may have met at his place of employment, but right now we can't confirm that.
Since we don't have identification of all of the remains that have been found, can you confirm or not if there is any danger to the public?
At this time, we don't believe that there are any other victims out there and that the person who is responsible for this heinous crime has been arrested.
Are you still searching for remains for Ms. Robinson?
Yes, we are.
Do you know where those remains could be?
No.
Have you found have you recovered a murder weapon in this situation?
Ongoing investigation.
Folks, we have time. Interest of time, 2 more questions.
Has there been a motive established?
Ongoing investigation.
What did you find inside that home, specifically in the basement?
Cannot release that at this time.
Is anyone else connected to the crime? Will there be more charges?
We have no evidence there's anyone else that's related to this offense, but as I stated before, it is an ongoing investigation.
When is the soonest that we can expect another update?
As soon as we get information.
Is he speaking with investigators? Anderson?
It's my understanding that he has retained a lawyer.
Is there anything you can say about the sex dungeon?
No.
All right, folks.
Just could you describe the crime? I mean, you called it a heinous crime. Just how are your investigators doing having to tackle this right now?
Well, just to know that someone has, been dismembered in a fashion like that, our investigators, they want to find justice for the victim. And so right now, that's what their focus is on. But, any crimes like this, it's bound to, at some point in time, have an effect on those who are involved.
Sheriff, thanks. Chief, thanks for your time. No promises, but there could be an additional briefing at a later date, sooner rather than later. If you have any follow-up questions, I wish I could tell you to call Sergeant Cornejo over there and not me, but call me. So, yeah, that would be. In any case, you don't have to go home, but.
Hey, can I ask you?
You can still see.
Well, apparently, I think we can watch this one as well, but just giving a little bit of a break. But I think I'm very pumped for this trial to get justice for Sade Robinson. I know, I'm glad he got caught as well. It's crazy how things has happened in this trial. And how horrible some of aspects of this trial are. In a way, I'm glad. I'm not saying, and I hope you protect your your mental health, whoever is going to go to the trial, the journeys of justice and Stephanie. But this is absolutely wild in terms of like the photos must be absolutely horrible to see. Be I don't even want it to describe, that's how horrible this trial is gonna yeah, it's gonna be tough. Yeah. Oh yeah, it is gonna be tough. And I hope they tell the family before they literally show pictures or anything. That they say to family, the family to get out. This is absolutely heartbreaking. There's, I think, one more video from Court TV that I want to watch, and I think that's all the videos kind of that I found. There is a lot of information, but there isn't like court hearings or anything much. So, but we're doing what we can in terms of preparing for the trial. And then next week we can jury selection is supposed to start Tuesday. It might take a couple of days, so obviously we might go back to Karen Reid for a day or two until we have word that there is a jury and there's going to be live stream, which I hope it is. So we'll see. I'm thinking of calling the courthouse, or if Stephanie could either call or journalist to confirm there's going to be live stream, if there's a motion or anything or not. Yeah, a lot of it is repetitive, and I don't want to get to a point that we are repetitive and we are like showing the same thing over and over again. But yeah. Oh, good morning, Retire Not Bored. Welcome back. Hello. It's so very nice to see you. Missed you, my friend. Oh, sorry. I'm waking up the baby. Cannot wake up the baby. Do not wake up the baby. Yeah, she's still asleep. Sorry, I'm babysitting my niece. She's over here. And I think I'm talking a little bit too loud, and she's not waking up. I think she can sleep through anything. But yeah, so I think we're gonna watch one more video, because then we can watch some parole hearings or something in preparation of the hearings we have coming up. We have 2 hearings coming. One that I am waiting on live stream to kick in for the Patrick Leoa murder, Christopher Shore trial, and then the other one is the Rodney Hilton one. And then we can watch we can watch the video about Rodney Hilton, and because that's another case that is going to be absolutely wild to follow. So probably we can go into that trial that one as well. Still going to be a hot minute until he goes to trial, but we'll see. But I will stop talking. Oh, okay. So we'll watch one last video about this Shady Robinson trial. Hopefully it's not the same that we were just listening to. Oh no, it is completely different. So we'll watch this one, and then we can, yeah.
This morning, we are turning the spotlight on the murder of Sade Robinson and how her alleged killer reportedly planned her death weeks in advance. Sade Robinson was last seen alive on a dinner date in Milwaukee with Maxwell Anderson, their first date, seen here in surveillance images from WITI TV. Cell phone records show that they ended up at Anderson's house, and then she was never heard from again. The next day, someone found a severed leg in a nearby park belonging to Robinson. Anderson is now accused of killing, dismembering, and leaving Sade's body parts all over Milwaukee. WISN television reports that a friend of Anderson's is now a confidential informant in the case. He told police that Anderson showed him a room in his basement where he planned to kill Sade. The search warrant indicated a plastic tarp covered a sanitation sink, and 3 saws were found in the room. The informant told police that Anderson planned on shooting Robinson and then dismembering her body in the room before disposing of her body throughout the city. Now, the defense has denied that these claims have any relevance and that this informant has any information. Let's bring in to discuss attorney and law professor Dante Mills and forensic death investigator, professor and host of the Body Bags podcast, Joseph Scott Morgan, is with us. Thank you both for sticking around with us. Joseph, I'm going to start with you. We've got this search warrant
that is showing things that were recovered inside of the home. A P-trap from the sanitary tub in the basement, a pipe in the laundry area, swabs of stain and cushions on a leather couch with different debris. I mean, they've got a lot of stuff from inside of the house. How is this, in your opinion, going to be connected and put in front of a jury to indicate that this was, in fact, something that was planned out and that it connects to Sade Robinson?
I don't want to step on my colleagues' toes here relative to and get too far off into the law relative to this, but I have to say that if anything smacks of premeditation, this does. This individual is purposed, and we do know this relative to dismemberment cases. You need privacy for this, and what many people don't understand is that when you have cases of dismemberment, it is arguably one of the most messy affairs that an individual perpetrator can engage in. Because of all of the physical evidence that's left behind. It requires a lot of preparation. You have to have knowledge, and then all those things that you don't account for, particularly at even a molecular level of the things that you're leaving behind. I don't want to be too grotesque, but when you think about, say, for instance, even elements of bone that are left behind as a result of sawing, undetected blood, for instance, and even skin tissue, hair, those sorts of things. And the fact that things would be lined with plastic goes to this idea that he was mindful of this. And I got to tell you, it really sends a chill up my spine, because it's hard for me to fathom that this would be his first time out of the gate relative to something like this. And maybe it's just something he's been planning for a while, and he started with this poor young lady. I have no idea, but this would have taken time and purpose.
There are many people who are poised listening to see if there are going to be any connections between this defendant and any other unsolved cases, because even in his home, there was women's clothing that was located in the beams. There was this bedazzled compact mirror that seemed to belong to a woman. So there are these and names in a notebook. So there's this possibility, but we can't go there until we hear from police if they've got a connection. Dante, can you speak to where this defense is right now? Because you've got this informant, and that really could just finish off this case for the defense, but they are disputing that this informant is actually legit. Should the state even go there? They got a lot of evidence otherwise. He was the last person seen with Sade. Do you put this informant on the stand who may have credibility issues?
Absolutely, because what it shows, and I thank the professor for leaving me an avenue here, is the means, motive, and opportunity of the defendant to have planned this crime and to have the ability to carry it out. So you want to, when you're prosecuting a case, you want to make sure you have all of the pieces in place, especially as something as grotesque as this, as something as gruesome as murder, especially when you're talking about the possibility that there could have been other victims or would have been other victims. You want to make sure that this person, if he is responsible for this, does not have the ability to do it to anyone else ever again. And that means following through with every piece of evidence that you can. So you want to pair the fact that you had her cell phone ping at his house to show that she was there. And then you bring in this witness to talk about the layout that he had, where he had the plastic. He said in advance that he was going to do these types of things. It's disturbing that he had another woman's ID at his house, a 27-year-old woman. So you want to make sure that you have everything included in your case so that the jury hears as much as possible and they have everything they need to come up with a guilty verdict if, in fact, he is responsible for this, and make sure he goes away for a long time.
Joseph Scott Morgan, how aggressively do you think detectives are following up on these leads? They're looking for the woman whose ID it was, the woman's name's in the notebook. Yeah. Are they aggressively going after this case, or are they really focused on Robinson, and if they are led to something else? I mean, inquiring minds want to know.
Full court press here. And I'm telling you, you have to overturn every stone in this area when you begin to think about forgotten individuals that are walking the streets, these sorts of things, and looking for any elements that might, any kind of foreign DNA that's going to be inside of that basement. And I have to remind folks that there are any number of serial perpetrators that are out there over the years that have kept mementos. I think most famously is probably BTK. Many people remember him, and he actually had a hiding place where he would keep elements. And, you know, they have, and I'm not a forensic psychologist, don't want to be one, but, you know, they go back and they fantasize about these things and they try to relive it. It's something they can hold on to, you know, long after a body is gone. So these little elements, you talk about things like compact mirrors and all these sorts of things, and even intimate items, you know, with underwear and things like this. And I have no insight into what they may have found. However, I think that it would be prudent for them to tear this house down or go through it as with a fine-tooth comb, looking for any kind of foreign DNA that does not tie back to that residence specifically. And they need to pursue every potential lead, because I don't know how many open cold cases they have up there involving females that might fit her demographic and her specifics as far as age and appearance. But I think that they're probably pressing forward with this.
Let me follow up with you, Joseph, because this home was sold. It no longer belongs to Maxwell Anderson. Another family, ideally, is living inside of it. And the prosecutors and police have said, look, we've gathered all of the evidence we need to. We can go back when we want to. But you're talking about a full-on, deep, detailed, it seems like, a search of this house. You mentioned the words tear down to get to this information. Do you think that that's possible to do when you have another fully functioning family inside of that home that's not going to really be happy about the crime scene being torn apart like that?
Yeah, well, I don't know. I would. It's interesting that this house was sold to somebody and they might not have had knowledge of this. I'm kind of interested in that aspect as well. But yeah, I mean, if the family's cooperating with the police, you talked about, or it has been mentioned, things being found in rafters, these sorts of things. It sounds as though they're going through every inch of this house. But that door has to be left open, and also any kind of further excavation that might need to take place in the surrounding yards as well. And let's keep in mind, he had various dump sites that he was going to. Famously, you know, we covered this on my podcast. Famously, you know, we had, I hate to talk about this so badly, so horrible, but limbs, you know, appearing out in the lake and this sort of thing that had been placed out there and had washed back ashore perhaps. Nothing is off the table here.
Absolutely. A gut-wrenching case, such a difficult one for the family of Sade Robinson, this community. Joseph Scott Morgan, thank you so much for your insight. Dante Mills as well. Joseph is sticking around. Dante, have a good rest of the day. Thank you for joining us.
Like, I agree there. That house sold too fast. And if the people then did not know what was that house was before, I'm sure they know now, because that is absolutely insane. But this is an insane case, you know, and how could they not know? Like, they know now. I'm sure they know now very well that yeah, exactly. It's the same thing. I agree, case one, absolutely. Oh my days, this case is absolutely insane. It's going to be a hard case to listen to. It is going to be a case that we're going to have to be going outside and touch grass a lot, for sure. Absolutely, is going to be one of those cases that is going to be great, but it is going to be a good case to get justice for Shady Robinson, and she needs it. We definitely need to get and be there for get justice for her. Um, well, maybe could be. I don't know. It's always a wonder who, like, I want to know how much that house did sell, because I would be rather interested into it. But that is the bit that we have on the Maxwell Anderson case. It is going to be a very sad case. It's going to be a very hard case to follow, but definitely one that we are going to be following here. This preview that we have a feed, which I'm sure it is, because I'm sure it's going to be. It is really well. I don't know. I'm not from around there, so. Yeah, this is definitely not going to help. It's going to attract a lot of people. I'm sure a lot of media is going to be on this case. I'm not 100% sure. I just need to finally tune the time difference, but I think it should be okay. I don't think the time difference between me and Wisconsin, it's that bad. I think it's only about 5 hours. What time is it right now there? Stephanie, the journeys, what time is it? So just I know not that it's gonna matter much, because we're still gonna follow it no matter what, this case. But yeah, so we are waiting now for a couple of hearings to come by. I am following several news stations for it. Oh, it's 9:29-ish. Okay, it's not too bad. So court would go until 11 o'clock my time. So it's not too bad. So we'll be about 11 o'clock. Finish, not finish. I can always ask Garden Bot to finish it off or something, but we'll follow this case no matter what. Sorry, I know I am not the most presentable person today, but I thought that since I'm babysitting my niece today, it's gonna be fine. So good morning today. Oh, it's okay, no worries. Thank you for tuning in. Good morning, Paula. I hope you're all right. We are now just finished the trial prep part of the stream, but there is a couple hearings before we do go. There is a couple hearings that I want to watch, and I want to be here for it. One of them is the Christopher Schur decision of if they're going to charge him again or not on the Patrick Leo's trial. That is going to happen in about an hour from now. And then just before that, in about half an hour in Ohio, Cincinnati, there is a hearing for Rodney Hilton. Oh, sorry, 1 second. 1 second. I'm gonna have to I'm gonna play a video about the Rodney Hilton trial case. So baby is crying, so I need to attend to baby. So give me a moment. There we go. So this is the arraignment for Rodney Hilton. No, it's what the trial. No, it's not today. Today is we are just doing some trial prep. There's no trial today. We are just doing hearings, catching up on cases and everything. So yeah. I don't know. It is crazy. This is another crazy case. Sorry, baby sim settled. So Rodney Hilton is accused of unaliving a police officer in Cincinnati, Ohio. That the police officer has unalived his son. So he did in retribution. So, but let me play just the arraignment, so I can settle the baby down. 1 second.
Penalty if convicted. Let's listen in to Judge Jody Lubers.
Here today because Mr. Hinton has been indicted by the grand jury on the two counts of aggravated murder with death penalty specifications, 1 count of murder, a specialty felony, and 2 counts of felonious assault. Mr. Hinton, if you want to be represented by an attorney but cannot afford one, I will appoint 2 attorneys who are certified by the Ohio Supreme Court to handle death penalty cases. If you hire your own attorney, he or she does not need to be death penalty certified. You can hire 1, 2, or as many lawyers as you want or can afford. If you are indigent and need an attorney appointed, I will select 2 attorneys that are certified by the Ohio Supreme Court. It is my understanding, sir, that you wish to hire your own attorney and in fact that you have retained Mr. Bennett to represent you. Is that correct?
Yes.
Mr. Bennett, you are representing him, isn't that correct? Okay, thank you so much. I do need to tell you, Mr. Hinton, I do believe that you have qualified for public defender appointment. Is that correct, Mr. Kennedy?
Yes, Mr. Honor.
And in fact, was an affidavit prepared regarding his indigency?
Yes, when Mr. Hinton was in Room A on third, he did speak to a qualified, briefly qualified as being able to be appointed counsel.
Okay, and was that affidavit filed with the clerk's office or with the courts?
It stays with the original case file and all the paperwork for that, but yes, it is an affidavit that stays with the financial qualification form in the file, and I have provided that original to the court.
Okay, and thank you so much for that. That does not get filed with the clerk's office. Okay, just wanted to check and be sure. Okay, thank you so much, sir. I really appreciate that, being here. Okay, all right, so you have Mr. Bennett as your attorney. That's fine, we're good to go. I just wanted to make sure that was clear. And so what we will do is we will begin with the reading of the indictment. So, Ms. Sarah, if you would like to begin. First I will ask, has the defendant been served with a copy of the indictment?
Judge, he had been served with a copy of the indictment, and I had one over the indictment.
Okay, wonderful. And is counsel prepared to waive any defects in the service of the indictment?
So waived.
All right, thank you so much. I appreciate that. Go ahead, Ms. Sarah.
So this is case number B25-02219. Rodney L. Hinton, you've been indicted with 2 counts, aggravated murder with specification, capital death penalty cases, 1 count murder, special felony, and 2 counts felonious assault. You've already stated that you received a copy of the indictment. How do you plead?
I live on behalf of the defendant. Not guilty. Excuse me.
Okay, all right. So, Mr. Hinton, I need to go over some rights with you, okay? So the first and the second count of the indictment are aggravated murder, and it is what is called a special felony, and it carries with it the possibility of the death penalty, which may be imposed, making this what we call a capital murder case. Although a capital murder case is procedurally much more complicated, most of the rights you have in a death penalty case are the same as any other type of criminal matter. The aggravated murder charge is also accompanied by one specification, which we will talk about in just a minute, okay? You are presumed to be innocent, which means the state of Ohio has to prove that you are guilty if they can. They do this by calling witnesses to the stand and presenting evidence. All the witnesses have to testify in your presence, and your attorney will have the right to cross-examine each of these witnesses to test their truthfulness, and this is the right of confrontation. You have the right to call witnesses also, and if there are any witnesses who will not come to court voluntarily, I will order them by court to court by way of subpoena, and this is the right of compulsory process. You have the right to have this case heard by a jury of 12 people. They would hear and decide the evidence. All 12 must be convinced beyond a reasonable doubt of your guilt in this case in order for you to be convicted. If the jury finds you guilty of the crime and the specification, they can recommend the imposition of a death penalty. They can also recommend one of the life sentences options, which I will talk about in just a minute. In the alternative, you have the right to waive a jury and have the case tried to a 3-judge panel. In this event, myself and 2 other judges would hear the case, decide the evidence, and if necessary, determine the sentence. The trial will be bifurcated, that is, divided into 2 parts. One is the trial phase with either the jury or the 3-judge panel, and the second is the sentencing phase, which would happen if you have a jury or a 3-judge panel. Either way, there's still 2 phases to the trial, okay? You understand? Okay. At the trial phase, the jury or the 3-judge panel will determine whether the state has proved beyond a reasonable doubt the crime of aggravated murder and whether the aggravated circumstances in the specification have been proven, also beyond a reasonable doubt. If you are found guilty of the principal offense, but not guilty of the specification, I will sentence you to one of the following sentences: life imprisonment without possibility of parole, life imprisonment without parole for 30 years, life imprisonment without parole for 25 years, or life imprisonment without parole for 20 years. If you are found guilty of the principal offense and the specification, we will move to a second phase of the trial known as the sentencing phase. The sentencing phase is presided over by the same jury or the same three-judge panel that heard the trial. At this phase, the state has the burden of proving the aggravating circumstances are sufficient to outweigh the factors in mitigation. The aggravating circumstance in this case is that the offense was committed and that the victim, Larry Henderson, was a law enforcement officer, and you had reasonable cause to know or knew he was a law enforcement officer, and either at the time he engaged in his duties or it was your specific purpose to kill a law enforcement officer. The prosecution has a burden of going forward with evidence that proves the aggravated circumstance. You have the burden of going forward with evidence of any factors in mitigation of the death penalty. Mitigating factors are those that lessen your moral culpability or diminish the appropriateness of the death penalty as a sentence. They can include your age, lack of prior criminal record, mental illness, etc. Just about anything can be a mitigating factor. The crime itself is not an aggravated circumstance, but it can be a mitigating factor depending upon the nature and the circumstance of the offense. You have the right to present evidence in the sentencing phase and have the right to compulsory process at this phase also. You have the right to remain silent at both the trial phase and the sentencing phase. This means no one can call you as a witness for the state. Whether or not you testify is up to you and your attorney. If you exercise your right to remain silent at the trial phase, the prosecutor is not allowed to comment on your silence, and I will instruct the jury not to hold your silence against you. At the sentencing phase, you can remain silent. You can testify under oath or make an unsworn statement. If you make an unsworn statement, you will not be subject to cross-examination. If the jury finds beyond a reasonable doubt the aggravating circumstances outweigh the mitigating factors, they will recommend a sentence of death. It is then incumbent upon me to make my own determination based upon a similar weighing process whether death is the appropriate sentence. If I agree with the jury's recommendation, I will impose the death penalty. If I do not agree with the jury's recommendation, I will impose a sentence of life imprisonment without the possibility of parole, or life imprisonment without parole for 30, 25, or 20 years. If the jury does not find beyond a reasonable doubt the aggravating circumstance outweighs the factors in mitigation, then one of the life sentences will be imposed. I will not be permitted to impose the death penalty without the unanimous recommendation from the jury. The verdict in the sentencing phase does not necessarily have to be unanimous. A single juror may prevent a death penalty recommendation by finding that the aggravating circumstance in the case does not outweigh the mitigating factors. However, all the jurors must agree before they can recommend a death penalty. If the jury is deadlocked and cannot reach a verdict at the sentencing phase, one of the life sentences will be imposed. If the case is being tried to a three-judge panel, a single judge can prevent the death penalty just like a juror can. If all three of the judges agree the mitigating circumstances outweigh the mitigating factors, the death penalty will be imposed. If the judges do not all agree on the death penalty, one of the life sentences will be imposed. A verdict resulting in the death penalty is automatically appealed to the Ohio Supreme Court. They will engage in the same weighing process as the jury and the judges to determine if the death penalty is appropriate. The indictment that you are facing also has additional charges besides the two aggravated murder charges. There is a count 3, which is a murder, which is a special felony, and that is a charge that carries 15 to life as a maximum penalty. There are also 2 felonious assault charges. Those are felonies of the first degree, and each one of those carries a possibility of 3 to 11 years at the Ohio Department of Corrections. Mr. Defendant, are you a citizen of the United States?
Yes.
And are you under the influence of alcohol or any drugs?
No.
Are you taking any medications right now?
Yes.
No?
Yes.
Yes, he is taking medication.
What medications are you taking, sir?
Laxapro.
I'm sorry?
Laxapro.
I can't hear you.
Laxapro.
Maxiprone?
Laxapro.
Laxapro. And what is that for, sir?
Judge, I'm on advice. You're taking medication.
I'm just asking to make sure that he knows what he's doing today so that he's of clear mind. I ask all, because he's entering his plea, that he's not intoxicated, he's not loopy, he's not under the influence of any drugs. I'm not trying to pry into anything, sir, but just to make sure he knows what he's doing here today.
I think he's fully aware of what's going on. And he understands what's going on.
So you don't think he's high on drugs, that he's competent to stand here today? That's all I'm asking, Mr. Bennett.
I don't think, I think he understands the nature of the proceedings.
Okay. All right. Then the plea is not guilty and will be entered as such. And anything else from the state?
From the state this time around, Jeff Gunn, Kate Rose, and John Destination for state of law.
All right, thank you so much. Anything else from you, Mr. Bennett?
No.
I know that it's been a no bond hearing has been set and heard by Judge Yates, and the bond is currently no bond. Okay, anything further from anyone? Okay, I have a couple other further things that I want to say. All right, the defendant will be held and continue to be held without bond. Okay, I have a few more rights that I need to go over with you, Mr. Hinton. You have the right to have your case heard within a speedy amount of time. Generally, a person charged with a crime has the right to have their case heard within 270 days of that arrest. This incident supposedly occurred on May 2nd of 2025, and as soon as your statutory trial date should be somewhere around the beginning of February of 2026. There is a separate statute that says you have the right to have your untried indictment against you to be tried within 180 days of making a demand that your case be brought to trial. You would have to make that demand directly to the court and send a copy to the prosecutor. If you have done that, then the untried indictment date would be on or about beginning of November of 2025. You also have a right to a speedy trial under the United States Constitution, but there is no math in the analysis of this right. Rather, there are a number of factors that the court must consider. I'm going to set this case for a scheduling conference in the next week. At that time, we're going to pick a trial date, and between now and then, the attorneys are going to talk. Your attorney is going to talk to you about whether or not you want to waive your right to speedy trial or not. If you are not going to waive a speedy trial, then we need to figure out when the speedy trial date is and set that case appropriately. If you have any questions about what your speedy trial date is, you need to talk to your attorney and have them advise me on this issue. In addition to the scheduling conference next week, I anticipate there are going to be a number of pretrial hearings and conferences between now and the trial. Because this is a capital murder case, you are entitled to have an extraordinary level of due process. This necessitates that I check on things with you from time to time where ordinarily we wouldn't have talked between now and the trial. I also might ask you how you're being treated in the jail, how the food is, how things are, and how you're getting along yourself and with your defense team and things like that. We are not going to discuss the merits of the case, your trial strategy, or anything of that nature. But if there is something going on with you that affects these proceedings, I'm going to want to know about that and what it is, okay? Okay?
Okay.
Okay. I don't want to hear about every little disagreement you have with your attorney, if there are any. I'm used to do this kind of work, and I know that from experience, sometimes there are disagreements and they're going to happen, so that's really pretty normal. But if there is a breakdown in communication with you and your attorney, or if no one's visiting in the jail or you're locked up or following any witnesses or discovery, I'm going to want to know about that. Okay?
Okay.
Okay. I'm going to put down a preliminary case management order that will probably be next week after the pretrial. And so that's going to list the caption of the case, how things are going to proceed, when motions will be filed, how they should be captioned, who's going to use letters, numbers, a whole list of information about how I want this trial to proceed from both attorneys so there's no misunderstanding. So we're all on the same page and so that everything goes forward smoothly. At this next conference that we're going to have, the scheduling conference, I would like to discuss a tentative date for the state to provide initial discovery and a bill of particulars, procedure for the retention of experts by the defense, and to set that trial date. I would like to also talk about any competency issues or any sanity issues that might be raised, if any. I would also be in a position to pick a lot of the dates and the deadlines for everything that's going to happen in this case. I would also like the defendant to remain retained in the Claremont County Jail. Okay, so I'm going to put on an order setting the bond, keeping it, remaining at no bond. I'm going to set the next scheduling date. I would like to meet next week. Are you all available next Thursday? And that would be what day? I'm sorry? 22nd. May 22nd. Could everybody meet? Do we have could we meet at like, do you want to meet at 9 or maybe 11? What would be better for council? Okay, thank you. 11 o'clock. So May 22nd at 11 o'clock. And then I'm going to put on the order that the defendant remained housed at the Claremont County Jail. Is there anything further from the state?
No, Your Honor.
Is there anything further from the defense?
No.
Okay. All right. Thank you all very much. We'll see you all next Thursday.
All right, so that is today in about 15 minutes that hearing is going to happen. I'm going to try, obviously, that's why we're going to carry on the stream, because I want to watch that hearing. I have a couple of possibilities of news stations a lot around this local area that have streamed this hearings before, so let's hope that one of them are gonna go and stream that. But keeping an eye, a very close eye, and refreshing quite often to see if they do come on as well. But I don't know if it is worth to play because this whole situation happened because Rodney is accused of unaliving a police officer, which that police officer has unalived his son, so it's kind of a domino effect. But yeah, that lawyer, I would be afraid of that lawyer. You are right. So the next video that I want to watch is the coroner actually discusses the autopsy findings of the son of Rodney Hilton, which is name, I think it's also Rodney Hilton. No, Ryan Hilton. Ryan Hilton was 18. He was unalived by a police officer. And the coroner is going to be talking about if he was a justifier or not. So what we're going to do is I'm going to stop playing that video, and then if the hearing starts and there is a feed, we'll be watching that. Otherwise, we'll watch the that. So it's just we can conclude, because in half an hour again we need to go to Michigan for the decision of the Michigan state to see if they're going to retry Christopher Scher or not on that murder trial as well of Patrick Leola. So there's quite a bit going on. Hopefully there is going to be feeds for everything that we need to cover today, and then we'll go from there. So let's just listen in now to the coroner discusses the autopsy findings on Ryan Hilton's autopsy out of this whole case against Rodney Hilton and this whole situation in Cincinnati, Ohio.
13 years as coroner, I've never been served with a grand jury subpoena. And I looked into it, and I believe, at least in the history of Hamilton County in the last 40 years, that hasn't happened to any of the coroners. So this was new territory. We had to learn some things. We had to consult some people. We had to ask a lot of questions. And so I decided putting off a press conference until we got some answers was the better way to handle things. So thank you for coming for the delayed press conference, shall we say, postponed. In the interim, I understand that some of the autopsy findings have been relayed to the public. And I just thought that the public should hear that from us, from our office directly, so that they get the facts straight and so that the information is correct. I want to start off with saying, first of all, our condolences to the grieving families, because this is not easy for anybody. And no matter what family you are, there are victims in this, and they're not just the people that have passed away. It's really the family members who are left to deal with their grief. So in the interest of hopefully easing some of the pain, and also to be able to provide the media, and you have sent me many written requests asking for the preliminary autopsy findings. And we've always worked well together in trying to provide the information and the truth to the public. So I'm counting on you to do that here. And so I thought I will give you a copy of this when I'm done with the press conference, but I wanted to at least give you the preliminary autopsy findings on Ryan Hinton. So Mr. Hinton had 3 gunshot wounds to his body. And this is in no particular order, but there was one in the left forearm, and there was an entrance wound and an exit wound, and it was soft tissue injury only. Did not contact any bone, and just skin wounds, entrance and exit. There was a second gunshot wound in the left lateral chest, so underneath the axilla, meaning the armpit, and that one did traverse the chest, and it did traverse through the left ventricle, and it exited the chest near the sternum. We believe that is the lethal wound. There was a third, basically just beneath the skin wound, and it was in the right posterolateral chest, adjacent to the shoulder, and it was soft tissue only. It traveled beneath the skin and ended just beneath the skull, and we were able to retrieve that bullet. So Mr. Hinton's cause of death is a gunshot wound to the torso. Left lateral chest, we believe, was the lethal wound. And his manner of death is homicide. So I wanted to make sure you got the exact facts from us. And
so she just said that the manner of death was homicide. So that means that the police officer unalived the Ryan, right? Which Ryan is the son of Rodney. So Rodney unalived the police officer that unalived his son. Wow. That is gonna be something else. This is like makes me remind me of the Stephanie Sheriff Stein's case out of Kentucky, but that's wild. Let's just listen to what she say. Still 9 minutes until the hearing.
Relay that to the public. And again, there are no words to express our grief and our sorrow to the family members. And we hope that this provides some solace to know the actual facts.
You ready to take questions?
I'm ready to take questions, but they're going to be limited to our portion of the investigation.
So can you talk about that, the bullet wound that killed him? Did that go through his arm and then enter his chest? Is that one bullet?
There is a possibility that that could have been the same bullet, because when you're running, usually you've got your arms contracted in a 90-degree elbow position, and you're running back and forth like this. So it's possible that the same bullet traversed the left forearm and into the left side of the chest.
If the bullet that killed him went in his side and out his sternum, which is his chest, does that mean he was shot from slightly behind?
No, it was straight from the side. This is mid-lateral side. And if you're asking why did it go toward the front, it did contact a rib on the way. So, as you know, when projectiles, and you can talk to somebody who's a physics expert or a firearms expert, when they hit something solid, they tend to deflect.
And did you recover that bullet, or was it the other? That was the one you did not.
Yeah, no, there were pieces of that bullet that we recovered, but not the entire bullet, no.
And he basically bled to death then would have been what happened.
We didn't have a scene response. We only responded to the hospital, so I'm not sure what happened at the scene. So.
The third bullet that you were able to retrieve from the right posterolateral chest.
No, it was recovered from the neck, just below the skull.
So you're saying he was shot in the back?
No, I said he was shot in the right posterolateral near the shoulder.
Almost that angle that you see in that body cam.
I cannot comment on the body cam. First of all, there was so much motion, and I am not a body cam expert, and I get a little motion sick anyway, so that's not my cup of tea. So you're going to have to ask somebody about the body cam footage. Yeah.
So can you then talk about where that bullet entered that body in plain speak and where it exited?
It entered the side of the chest. It impacted the left 7th rib, and then it traveled through the left side of the chest, through the left ventricle, and then out the front.
And then the other bullet, how would that bullet have, in plain speak, entered and exited?
It entered, plain speaking, I mean, I'm a physician. This is right posterolateral chest is, near the shoulder, and then traveled up underneath the skin, and then ended at the base of the skull without impacting bone or anything along the way. It was all soft tissue beneath the skin.
That would have had to be then as he was going down.
You're going to have to talk to somebody about that, because again, I can't comment on the body cam footage or what position his body was in at the time. And I can't also tell you which gunshot wound preceded which. I don't know the order. I can just tell you the gunshot wounds there are 3 entrance wounds and 2 exit wounds.
But it's possible that there were only two bullets that hit him.
It's possible.
Well, go ahead. From a legal perspective, what allows you to talk today that didn't allow you on Friday?
I didn't know that I wasn't allowed on Friday, but I didn't have enough information, and that's why I had to postpone the press conference until I gathered some more information about what my requirements were with respect to the grand jury subpoena, and that's why I took the time to get the information before I proceeded with the press conference.
What does that mean that you got this subpoena then?
I don't know what that means. I mean, it's a grand jury subpoena asking for materials, and like I said, I've never had one before in the office, so that's why I needed to find out what that meant.
It didn't stop you from relaying any of this information then?
Not today, but I didn't know what that meant when I received it, so I felt compelled to postpone it until I got some more information, and then made a decision then to go ahead and move forward with the press conference.
Does the reason why you wanted to hold this press conference, obviously you said it was to ease the pain of the grieving families. Does it also perhaps ease community tensions?
Well, that is my hope. And I think in my 13 years of being in the office, being transparent with the public and the media with what we find and what we have found has been something that we routinely do. And that's part of what I've done in the office is I want to be transparent because I think you have a right to know. And I think the family has a right to know. And so we wanted to present you with the actual facts and not have conjecture out there with somebody saying this and somebody saying this, and and it's all confusing, and then the tensions are going up. So let me provide you with the actual facts, and that's what we are doing here. The other thing is that the family and the prosecutor's office have both been provided with what I'm going to be providing you. The family has also obtained their own private autopsy, so they have findings. They already know their findings. I'm sure that's been shared with them. So this is what we found in our office.
What day do you report to the grand jury?
I don't think I'm allowed to discuss that.
Can you kind of just, like Dave, can you kind of point to where it is on the body?
You know what? I didn't do the autopsy. So I'm looking at the report, and
Is that going to be on what you give us, like the exact spot where it is?
No, we don't do diagrams or anything like that. I mean, that will be provided.
Because when you say, I'm not thinking like this area, and then the other one is like here or here. I'm a little confused on exactly where.
This is what I got from our pathologist. Yeah. So.
When did you finish the autopsy, and what was that communication with the police department? With them saying it was, through the chest, kind of where was the miscommunication there, and what is going to be done moving forward so this doesn't happen again?
Well, this is why I ask that we provide the autopsy findings from our office so that you get.
Okay, all right. Could we bring him in if you're good? Okay, great, thank you.
All right, this is live from the courtroom. The Hilton. This is live from the courtroom, the Hilton hearing that we are just covering. So this is what we've been waiting about. So there is a feed. So here we go. This is live from the courtroom.
If it goes off, I see.
So we'll see. The defendant is going to come in, and we're going to watch. It's a live hearing right now of Hilton in a courtroom, and of the case that we've been discussing. The one that shot the police officer, that the police officer killed his son, and is back in court. Let's listen.
Mr. Bennett, would you like your client at the podium or at the table? Okay, might be a little while, but that's fine with me. Okay, so we're going to call State of Ohio versus Rodney L. Hinton. This is case number B2502219. We're here for report, conference, scheduling, hearing today. So, Mr. Hinton, how you doing? I'm okay. Okay, so I just want to ask you, how are they treating you at the jail? Fair. I'm sorry? Fair. Can you turn that? Fair. Fair? Yeah. Thank you, sir. How's the food? It's okay. It's okay. Are you getting along with your defense team? Yes. Okay. All right. Okay, great. So we're here today. It's just some things I want to advise the defendant, and then I'd like to pick some dates for scheduling. So Mr. Hinton and Mr. Bennett, last time we were here, I talked to you about your rights, and I think I went over all your rights with you. And I did explain to you that you hired Mr. Bennett, which is fine. You can hire anyone that you want. But Mr. Kennedy was here and did tell me that you qualify for a public defender because you are indigent. So I just need to advise you further, sir, that I know Mr. Bennett is your counsel, but you do have the right to have a second attorney appointed for you from the public defender's office. Actually, I would be the one who would appoint someone from the list who's qualified and Supreme Court certified. And I would not do that, sir, unless you ask me to. And if you want me to do that, I certainly will. But if you don't, I will not. And that's totally up to you and your team to decide. Okay? So I just want to advise you of that. If you do want that, I would prefer that you let me know sooner than later. So if you get somebody on board right now, not like a week before trial, they have to continue the trial. You know what I'm saying. But if you want that, just let me know. Okay? Okay. Okay, Mr. Bennett, you good? All right. With that being said, every hearing I want an entry signed by the defendant and defense counsel and the state for time, for waiving of time, whether time is waived or not. I have a proposed entry, Ms. Murphy, do you have it? Want to print it out? Did you give it to both? So I will have this entry every time that we have a hearing, continue to the next hearing. Just want everyone aware of it in case I forget to mention that. Make sure you get it from Ms. Murphy every time we've got something going on. Okay, I want to talk about speedy trial. And I want to talk about when this case needs to be tried too, so that we're all on the same page. I have the date of arrest as May 2nd. What do you have it as, Mr. Guinan or Ms. Burroughs? May 2nd. May 2nd. Okay, Mr. Bennett?
May 2nd.
So do we all agree then that the time starts on May 2nd?
Yes.
Okay. The state? Yes. Oh, one thing we all agree on. Okay, that's awesome. That's a great way to start. Thank you for that. Okay. So what day do you think you have right now, assuming no waiver of time, when do you think this needs to be tried by?
July 31st this year.
Okay. Mr. Bennett, what date do you think it needs to be tried by?
July 31st, 2025.
We all agree. Okay, great. Mr. Bennett, when you were here last time, you told me you were not waiving time, and I said, great, and I think that was written on the entry. I do know, sir, you have filed a demand for discovery, which I understand from the Supreme Court waives time. So I just want to be cognitive of the time in this case. If it's waived, great, everyone agrees and understands. If it's not, we all agree and we understand, and I don't want any time issues. Okay, everybody good with that from the state?
Yeah.
From the defense?
Yes, Your Honor, my understanding with the demand of discovery that would waive time from time to time, which would be 11 more days. So, trial date would be August.
Well, did you get discovery today? I think it's until you get, I don't know that it's till today. I think it's when you get the discovery from the state. Now, there has to be a reasonable amount of time that the state is given to provide discovery. I mean, they can't delay and give it to you, in 2 years. That would be unfair. But okay, but I disagree with you, sir. I don't think today is the day. I think you're still waiving till they get it to you within a reasonable amount of time. Do you disagree with me, Mr. Bennett?
I agree with you wholeheartedly. My point was that I got discovery today. Stop, but I don't have it. So it's still going on. So we're saying the same thing.
Thank you very much. Is the state on the same page as Mr. Bennett and I?
Yes.
Okay, great. All right, well, what I would like to do today, I obviously have not provided discovery to Mr. Bennett, and I don't know when you will, and if you can give us a date when you think that would be accomplished, that would be great. I want to do a scheduling order today, and I would like to pick a trial date, if we can today, and several other dates and deadlines for filing motions, final pretrial, and I asked Mr. Sykes to come up here today. Thank you so much, Mr. Sykes. Also to assist us in the jury questionnaires, jury hardships, when the jury's coming, so we can all talk and be on the same page, because I would like to pick one trial date and one trial date only and have it go on that day, if it can. Okay? Everyone good with that? Safe? Defense? Mr. Bennett, are you okay? Okay.
I'm very willing and able to do that. There are a lot of things in the depth of the case that have impacted whether or not the case can be tried at a certain time with that concern. The discussion, they got to do background, the defendant and stand. There could be a response to the expert guideline list. With that, though, I can still set a date. I don't know how soon.
Understood, but I know you're busy. I know the state's busy. I'm busy. But if we can pick a date today and work towards that and then work back from the dates, and I know it's not going to be tomorrow, and I really don't think it's going to be July. I'm okay with that, but I'd like to get a date today if everybody's comfortable picking a date. So is the state comfortable?
Yes.
Mr. Bennett, are you comfortable picking a date today?
Yes.
Okay, so assuming, Mr. Bennett, we're not going to go July 31st for a trial, right?
Correct.
And the state would be correct?
Yes.
When, Mr. Bennett, I defer to you, when are you available? When would you like this trial set?
October 6th.
You'll be ready in October. Okay. October 6th, Murphy, start looking at that for us. From the state. to look throughout that month. We got any other murders or any sex offense case, any big cases set throughout the month? Probably gonna 2, maybe 3 weeks block out. I'm hoping 2, but I don't know. That's okay.
All right, I have a murder set on the 6th before with Mr. Roswell.
Oh, Miss Murphy, do we have a murder set that day? Is that likely to go?
It's very early, I assumed it's from Ms. Polston. Ms. Levin from my office is on with me. Mr. Croswell was unavailable for that date for you about a month ago.
Is this client locked up?
No.
Any idea if that's, maybe you don't even know, but any idea if that's likely to go or not?
I don't have any discussion. We sent him a little bit of supplemental discovery about 3 weeks ago.
Okay, what else we got? Those first 2 weeks or 3 weeks of October, Murphy, can we do that? We're good? The rest of the week, the next week, and the next week? Okay, looks like we got a trial date of October 6th. Okay, I'm gonna do a scheduling order today, so I'm gonna write in here 10, 6, 25, 9 o'clock for jury. I do a final pretrial a week before. There will be many dates before that, but I like to do one final pretrial a week before. Ms. Murphy, when would that be? I can't hear you. September 30th. Council, is everybody available September 30th? Before I write that down?
Yes, sir.
Thank you.
Yes. Yes, let me see.
Okay, that will also be at 9 o'clock on September 30th. Okay, so Mr. Sykes, thank you so much for being here. I think I need several dates regarding you and the jury. I would like a hardship hearing date for jurors who come in who have hardships, vacation, illness, age. The typical hardships that come in on every single case that we would get when you have juror summons that go out. What I'd like you to do is I'd like you to meet with counsel, go over those hardships, see if you guys agree that people can be excused, and if they can't. This is before we're even bringing them in. You both sides know what I'm talking about that. When do you think is a good date for that, knowing the trial date is October 6th?
I'd say 10 days prior to that, to establish the not previous Friday on October 3rd, but the Friday prior to that is that September
28th.
September 28th would be that, if that's that Friday. That would give us anywhere from 3 weeks for jurors to respond to the summons, and a week for us or so to send notifications to the excuse.
And we're going to get to that. I may have jumped the gun a little bit, but we'll do 10/26 for 9/26. Thank you. I'm glad you're listening. 9/20. I wrote down 10 too. 9/26, 25 at 9 for juror hardships. Okay. The date that the jurors would actually come in, Mr. Sykes, that they would come in, they would do a screening with you, they would get the questionnaires to fill out and return to you, and then you share with counsel before the trial starts. Typically it's the Friday before the trial starts, so that would be October 3rd. How does that work with everybody? I'm hearing nothing, so I'm going to take that. Mr. Sykes, please correct me if you need more time or I'm off base.
No, I think that should be fine.
Okay.
Allow us time to make copies of the questionnaires to go and get it ready for the trial.
Okay, and then on my schedule order, I have jurors return and jury selection begins, and that would be October 6th, because that first day of trial is actually jury selection. Okay. I would like to pick dates for the date that the initial jury summons goes out. If there's a short form questionnaire or go out with that jury summons, no. Okay, so just jury summons going out. Is it about 4 weeks before the trial date?
About a month before the trial.
Okay, so if the trial date is October 6th, what would you like, Mr. Sykes?
Is 9/6, Monday through Friday?
9/8 is a Monday, September 8th, that's not Labor Day, is it? Versus Labor Day, September, so September
It'd be September 5th.
as a Friday, would you like that? Okay, so I'm gonna put that in here, September 5 for jury summons. Any requests for a continuance I would like by either side made before that date, okay? September 5th. It's like a month before trial, somebody needs a continuance. You can make it before then, but I would like that to be the cutoff date for a request for continuance. Okay. Then I want to pick dates for proposed long form jury questionnaires from counsel, which you would like submitted in the questionnaires. When counsel would you like to, knowing that they're not going to get them obviously until that Friday before, when would you like to come in and talk about the questionnaires so we have those time to prepare them, get them made, and have them ready for that day?
The week of September 9th is fine, or September 8th.
Okay. So you want to meet on September 9th? Okay, so proposed long form jury questionnaire from counsel. I need those filed on by the 9th, September 9th, and then we can discuss on the 9th at 9 o'clock. Those okay? Or do you want a different date for a hearing on those? Do you want to submit them on the 9th and you want the hearing on the 9th about those, or two different dates?
I would prefer at least a day, because it'll be the first time we get to see it both councils.
Okay.
Questionnaire, we'd like some time to review that.
Okay, that makes sense. Let's do 9/10 then. 9/10/25 at 9 for a hearing. File them by 9/9 at 9. How about that? And then 9/10 the next day at 9 we'll come in and we'll discuss. Okay? All right. Discovery. You want a discovery deadline? Do you want to select a discovery cutoff deadline or not? Nope. Okay, so I'm going to put non-apply on that line. Dispositive motion deadline. So I've got motions, if there are motions to suppress, I want filed by a certain date. If there are the standard motions that are filed in these type of cases, formal pretrial motions that should be heard at the pretrial, but then usually in these capital murder cases, there are a slew of motions that are filed. So I would like a dispositive motion deadline to be filed. What day would you like, Mr. Bennett? Because it's usually from the defense.
Because I've been told that it's going to take approximately 45, 60 days for you to have all of the starting cases. So I would ask for a motion deadline in 30 days after.
Okay.
30 days after 45, 60 days, so about 9 days.
Okay, so about 90 days from now, we're helping with this 1, 2, 3. Do you want it like,
July 31st.
from today? Well, June, July, that would not just be 60 days? Did you say 90?
I'll be about 90 days, July 31st. That'll be 90 days.
How many days are that? So it's like you're saying.
Oh, from data, I mean from today. Okay, so you want, what do you want, July 31st?
All September 1st, or all 31st.
No. I need a date, the deadline for you to file your motions. What date do you want?
August 31st, because I'm not going to have all the discovery until about 45, 60 days.
Well, no, here's my, okay, so we gotta be careful here. So you gotta file your motions, and they need like at least 2 weeks to respond. And then I gotta set them down for a hearing, and we're getting pretty close to the trial date. Don't you want these decided before the trial? I mean, if you don't, you want me to decide before the trial, I will, but I would think you'd want some time for, and I'm not trying to put words in your mouth, but for strategy and trial purposes. I can do that, Mr. Bennett, but we're getting pretty close to that October 6th jury trial date. This is why we're talking about it.
I need that August 31st day. The court is going to extend it, that's fine. I can't file the motion until I have all the discovery. We need about 30 days after all the discovery to determine what the file motion may or may not be approved.
Understood, so.
I need about 30 days from after the time that the discovery, I
45 or 60 days that you're gonna get them discovery. It's gonna matter, we might have to move this trial date back because, again,
If we have to do the deep and on the error side, so in 60 days.
so you will get discovery to the defense 60 days from today or 60 days from the date of arrest?
60 days from today.
So today is May 22nd. So July, like 21st, is that when you're gonna have discovery?
Yes, but if we don't have a discovery cutoff, I'm hoping you can not hold us to that. We are going to do our best to get as much discovery as possible. We'll shoot the venue with all the discovery by July 21st. As of today, over 300 items being logged, and there are still more to go. There is a number of body worn cameras in this case because of the sheer number of officers who responded to the scene. It is incredibly large.
Okay.
We will need time to review that.
Understood. Again, though, I'm watching time. I want to be cognitive of the time that you need to get everything, cognitive of your time, Mr. Bennett, to go through everything yourself and with your client, and then time to file your motion, then to respond and me to hear it, and then try the case. So you guys, I don't want to change these dates, but I'm certainly flexible with the dates that I will give you. So you tell me, I just want to meet these dates and I don't want to have to delay this. So if you need more time or if you need the trial pushed back, let me know that. I'm fine, but I don't want to change these dates. And be fair to everybody. Yeah, sure.
Judge, I believe the state has been requested that we set January.
For trial? Okay. Can you print me out a first and second page again? Absolutely fine, and I appreciate you both. We want to do this and we want to do this right, and we're going to take the time that everybody needs. So I applaud you for that. Thank you so much. So, page 1 and page 2, if you don't mind. Now I'm going to need you to go back to the calendar and look at January. I think I'm pretty good in January myself. How are you all? What day would you like to go in January?
Second, third week.
We agreed on the second or third week, we started leaving the 12th and 19th. The 19th maybe
Which, am I good either one and for the next couple weeks after that?
yes.
Okay, I'm good either day, either the 12th or I guess the 20th, right? Which day would you all like?
I believe that's what's happening.
Okay, so we're going to pick a new trial date, a January 12th of 2026. You're willing to waive time, correct, Mr. Bennett?
Yes.
Thank you so much. We'll do a final pre-trial, Ms. Murphy. Can you give me a date the week before? January 6th, is all council good that day? Thank you so much. 2026 at 9. Okay. Hi, Mr. Seitz. We're going back to a hearing date for juror hardship. So maybe I should go back and say the date that the date that the summons go out 4 weeks before the trial would be
sometime the week of December 8th.
Okay, because December 12th is a Friday, so what day would you like? Do you want to do December 8th? That's a Monday.
Let's do December 10th, if that's okay.
Okay.
Monday is probably the last week we'll bring jurors in for the year, so I think I probably waste that.
Okay, I'm gonna say 12/10/25, that will be the day that the jurors report. I'm sorry, that will be the day that the jury summons go out, okay? And then the date that the jurors should report would be that Friday before the trial date. 1/9, thank you very much. 1/9/26 at 9, the jurors report. The date for the juror hardships, what would you like for that, Mr. Seitz?
Technically January 2nd to give us a week to respond to anyone's excuse that they don't show up.
Okay, Counselor, you, January 2nd, the juror hardship day, that's a Friday.
That's a day,
Right.
I'll let it go.
Okay,
The state is not.
okay.
I will be out of town, usually on Monday the 5th instead.
I can do that.
Could Ms. Bennett, okay. All right, so January 5th, 26 at 9 for juror hardships, and the jurors will come to begin the trial on January 12th. Okay. Now, proposed questionnaires from the council, what date would you like for that? Beginning, you want to do the beginning of December? So, might out that first week of December. You want to do sometime the first week of the 8th of December? What day would you all like to come in and talk about? Well, I need.
You want to go on the 10th of December and say that you were something about.
The what day? 10th? Okay, so if you could each file your questionnaires on the 9th and then we could meet on the 10th, does that work?
Yes.
12/9, they will be filed, and then we'll have a hearing on 12/10 at 9 o'clock. Okay, great. Moving on. Okay, so then, Mr. Bennett, we're to dispositive motion deadline for you. You want like October? What do you want for your dispositive motion date? And again, I'm going to go through dispositive motions, which are the general ones. Motions to suppress and then pretrial motions. Because I think there's like, I consider them like 3 categories. What day would you like, sir? So how about October 27th is a Monday? Could you do that?
Yes, the state can.
No, this is for the defense to file their motions. Okay. Okay. 10/27/25. Now, how much time does the state need to respond?
2 weeks.
Okay, so that would be November 10th. And then I want a hearing date on this motion. You want to do it November 24th? That's the Monday before Thanksgiving. That work for you, Mr. Bennett?
Yes.
First for the state.
Okay, November, please don't work for us. Okay, at 9 o'clock? Okay. Motion to suppress evidence. I know that's kind of hard for you to say, Mr. Bennett, if what you're going to file, maybe you won't even file, but I just need to put a deadline for that. What would you like? Sure. 10/27. Thank you very much. Do you want me to, I'll put the same date for hearing for a motion to suppress on the same date 11:24, okay?
Yes.
Thank you very much. Any other pretrial motions that you would want heard at the pretrial? I'd like to have you set like maybe a month before, so you have a time to respond, and then we can just discuss them at the pretrial. So I'm thinking like, what about, could you file them by say December 8th? Any pretrial motions? That would give you 2 weeks for the state to respond to the 22nd, and then we could hear them on the pretrial on the 6th. That work?
Yes, sir.
Okay. So 12, 8, 25, all other pretrial motions, and the state response. Murphy, I know I'm changing this up a little bit. On the 12/22, and then hearing at the pretrial. And there might not be any, but at least we have them set down, okay? Okay. If there is a request to view the scene, which may or may not decide either side, I want that a month in advance so I can make the appropriate arrangements if we need to do that. So if the trial date is January 12th, I'd like that filed by December 12th. Okay? Jury instructions. Jury instructions, I also would like a month in advance, so I would also like those on the same day. 12/12/25, any requested jury instructions? Okay. I would like to have a pretrial or report day, whatever you want to call it, every month, once a month, just to check in on everybody to see everyone's going. It doesn't have to be the same day every month, but it can be. So I need a pretrial date in June. So I'm thinking, I don't know, you guys have a preference on a Monday, Thursday?
Probably issue of June is where I'm available the week of June 23rd.
Okay. It would be helpful to have like the same date, like on Mondays or Thursdays, is what I'm asking. Does it matter at all?
No.
Okay. Well, then I'm going to pick, am I here June 19th? Oh, okay, that's fine, I'm free. How about June 18th? June 18th, would that work?
Yes.
For everybody? Okay, June 18th at 9. I'm not going to take the rest of the days now. How about July, can we do July 9th at 9? It's a Wednesday. Yep, sure. Thank you. How about August 13th? August 13th. You guys know you're ready. Check your schedule.
Yeah.
September, no, I want September, am I here September 10th? No. How about the 17th? Yes. September 17th?
Yeah.
I would just know we're all going to be here on the 10th for a hearing on the questionnaire. So
Oh, okay. Apparently we're not.
We moved it.
Or is it that's the old one?
That's all.
Okay, sorry.
Okay, no.
So many meetings.
So September 17th for report?
Yes.
Okay. And then October, we do October 15th, right?
Yes.
And then we're here, let's see. We're here on November 24th. I think that's okay. Do you want another date that month? Check in? Okay. All right. Great. Do you think there's any other dates right now at this time that we need to select or anything? And we can always add, but I'm just trying to get a schedule at least right now for everybody while we're here. Okay.
You got everything done.
Okay, great. So I'm going to tell you that every regular pretrial, every report, every conference that's scheduled by the court, I expect all counsel to be here, okay? The counsel, all three of you, okay? All motions to be filed by the prosecution and the defense shall be numbered in sequential order, and each motion shall have a caption including briefly the nature of the motion. Hi.
Sorry, one more thing on the hardship date, because that's a Monday and we'll be bringing regular jurors in that day as well. Just so counsel knows, I would have to be after 11 o'clock that day to be to present the excuses to you all.
Okay.
So I don't know.
Why don't we do the 6th? Why don't we do it Tuesday the 6th?
It'd be hard to get the notifications out in time before the 9th. Because these are to send the notifications to the jurors who are excused so that they don't show up to fill out the question.
Oh, I see. For you to notify them they don't have to come.
Yeah.
Okay.
So the 5th, it's just, I have to do the orientation until 10 and then kind of sort out the rest. So anytime after 11 o'clock.
So I need to pick a specific date, time.
Yeah.
What time do you want? 11?
I can do anytime after 11.
Can you do 11?
Yeah.
Can you all do 11 instead of 9? Yes, sir.
Yes.
Okay, thank you, Mr. Seitz. I appreciate that. Great, that's great.
January 5th at 11 or
January 5th at 11.
Every sentence.
Okay. So all motions to be filed by the prosecution or by the defense counsel shall be numbered in sequential order, and each motion shall have a caption indicating briefly the nature of the motion. All motions shall be in chronological order, starting with prosecution 1, defense 1, and continuing in a sequential order thereafter. Counsel, upon filing any motion, shall indicate on the caption of said motion whether an oral hearing is requested or whether the court may rule on the motion without a specific oral hearing. All motions filed shall have an appropriate response by the opposing party within 14 days of the filing date of the original motion, unless leave of the court has been sought and granted for good cause. If there is no response, the court will consider said motion to be unopposed. The prevailing party shall be responsible for the preparation, circulation, and presentation to the court of a journal entry consistent with the ruling of the court. Potential long-form jury questionnaires shall be submitted by the defense to the prosecution. I said 10 days prior to the date indicated. We said 1, didn't we? 1 day prior to the date due indicated by the court in the scheduling order. The prosecutor may respond to the defense with any objections and additional questions within 1 day. Thereafter, the defense shall prepare a proposed questionnaire and file it by the due date indicated, and the prosecution shall file any objections or requested additions within the 1 day. Thereafter, a hearing will be conducted unless the parties submit an agreed questionnaire by the due date indicated. So if you guys want to get together and do your own, and you all agree, just submit it to me, and that's fine. Okay, copies of all motions, pleadings, or other related matters shall be filed with the clerk of courts, along with courtesy copies delivered directly and in person, delivered to my court bailiff in the courtroom. I know you file things and we get copies. I want them personally hand delivered to Ms. Murphy, okay? The jury commissioner shall summon jurors from the regular jury pool to appear at the jury commissioner's quarters on Thank you. December 9th to 26th for administrative processing. Thereafter, the jury commissioner shall report to the court a list of the jurors who have responded and direct each juror to courtroom 340 at 9 o'clock on the day of trial, which is January 12th. 26th. Copies of the completed juror questionnaire shall be provided to the court, and copies to all counsel of record upon same being received by the jury commissioner. Jury questionnaires provided to counsel shall not be distributed or provided to any person other than members of the prosecutor's office, the defendant, and other individuals working on behalf of the prosecutor or defense counsel in handling this matter unless further permitted by the court. Persons with such access shall not in any way attempt, either directly or indirectly, to contact said prospective jurors in any manner whatsoever. All jury questionnaires will be collected at the conclusion of the case and retained by the jury commissioner subject to further order of the court. No further copy of the jury questionnaire shall be permitted for any purpose without the express written approval of the court. Trial counsel shall be responsible for ensuring that these instructions are communicated to anyone working with them and that these instructions are complied with. Parties are to comply with all requests for discovery and all orders regarding discovery in a timely fashion. Parties shall proceed with discovery forthwith and with all due diligence. Any problems or disputes regarding discovery shall be brought to the court's attention immediately through the filing of an appropriate specific motion concerning the discovery requested or any discovery denied. All experts, now we didn't pick experts, expert deadline date. Do you want an expert deadline date or not?
I think that's a good idea.
Yeah, I do too, now that I'm thinking about it. I didn't put it. Further, I was going to address this later, but I might as well address it now. I don't know if there's going to be any requests for competency or MGRI. And if there is, fine. If there isn't, that's fine too. However, I want to put both sides on notice right now. If there is a request for such, and I will take it and entertain it and get a report, but I want either side ready and prepared to have, in case they would like a second opinion, to have someone in line approved and available. I will not wait and delay this trial because either side wants to get a second opinion and they're not ready with that. Just putting you on notice of that, okay? You understood? Okay, let's pick expert cutoff date. So plaintiff, expert cutoff date, what do you want?
Well, if I could suggest, state's expert would probably be in response to it, and it may or may not have.
Okay.
As far as state expert, I would suggest the date of December the 8th, we already selected. All of the events motions to be due. That would certainly comply with expert reports and preparation. Just a suggestion.
You want your expert by then, or you're requesting that to be his expert?
Well, my hope would be that would have his expert, if any, by December 8th, so we can file his motions. That was the deadline we previously selected, recall motions. I think it would just make sense to make that our expert deadline with Mr. Bennett sometime in early November.
Mr. Bennett, are you okay with that? Okay, what day would you like in November, Mr. Bennett? Which day would you like? Okay, November 12th, 25, the defense will disclose their experts. December, so that's November 12th. December 8th, the state will disclose their experts. Great, thank you so very much for the agreement on that. All reports retained by either the prosecution or by defense counsel shall be advised immediately of discovery deadlines and the trial dates set by the court in this matter. I'm not continuing because your expert's not available. You just pick the trial date. You understand? Counsel shall confirm with all experts their availability for trial and shall provide notification to the court that the experts have been advised of their availability and of their willingness to work within the time periods set herein. Counsel for the prosecution and defense counsel shall issue appropriate subpoenas for witnesses, and counsel shall schedule witnesses so as to not cause unnecessarily delays during the trial procedures. Counsel will be expected to have witnesses available during all normal trial times or at such other times as the court may order, and that the court will be in session so as to not cause unnecessary inconvenience or delay to the trial jurors. During trial, counsel for the prosecution and counsel for the defense shall maintain vigilance on their respective witnesses to be called by each side so as to not violate any order regarding a separation of witnesses if there is one. Any counsel not complying with this order may have the respective witnesses potentially excluded from testifying unless good cause is shown for the violation of the court's separation of witnesses order if it goes into place. The court anticipates that the trial will be held from 10 a.m. till 4 p.m. each day with an hour for lunch and any other recesses upon request as the court deems necessary, Monday through Friday until the trial is concluded. Counsel for the prosecution and counsel for the defense shall provide the court no later than the final pretrial in this matter with potential expected witness lists for the court's use in seating the jury. Should any updates occur in potential witnesses named after the final pretrial, they shall be provided to the court prior to the seating of the jury. Defense counsel shall be responsible for securing appropriate street clothing for the defendant. Defense counsel shall be responsible for seeing that any street clothing is provided to the appropriate authorities at the jail for processing 1 day prior to the trial. Requests for a jury view shall be provided with particularity, including the specific address to be viewed and any special instructions to be provided to the jury. The bailiff will make the necessary arrangements concerning transportation, subject to final approval by the court. Unless otherwise ordered, any view of the scene will be conducted after the oath to trial jurors and before opening statements. Defense counsel shall notify the court at least 1 week prior to the scheduled view regarding the defendant's wishes to attend the view so that security may be afforded if necessary. These items shall be discussed by counsel with the court at an appropriate pretrial conference. Pretrial conferences may take place initially in the court's chambers with counsel presence, but not likely. All substantive matters will be discussed and or argued on the record. The court may handle purely procedural matters on the court record after all pretrial conferences. Any party may request the right to put any item on the record after a pretrial conference as may be deemed necessary by counsel. Unless waived, the defendant will be present during all matters which are placed on the court record. All counsel are expected to attend all pretrial conferences unless they are excused by the court. Counsel shall be prepared to discuss all respective issues necessary at any pretrial conference. This court shall reserve the right to make further orders concerning any necessary court security for the protection of the defendant, the parties, counsel, and others. The parties are further instructed to raise any security concerns with the court as soon as possible. Should counsel need any audio, visual, or other technical equipment, counsel shall advise the court no later than the final pretrial so that this equipment is available on the date of the trial. The court reserves the right to make any further orders concerning the proper handling and accommodations for family or friends of the deceased and of the accused. Proposed jury instructions shall be filed.
All right, so I think that's where we're gonna leave the Rodney. I don't think there's gonna be anything more than we need to know. I think it's just more setting dates and everything. We've got the dates that we needed. We can revisit at any time. But let's go to Christopher Shore. So it's already been going on for the last about few minutes, so we can catch up. It's okay. Where they're gonna decide if they're gonna retry Christopher Shore in the death of Patrick Leoa or not for the new trial. So if you remember, a couple of weeks ago, we were covering this trial. After 4 days of deliberations, more than 20 hours of deliberations, the jury could not come to an agreement and a mistrial was declared. So when that happens, the prosecution decides or not to go forward with the same charges, new charges, or what is going to happen in this case. So that's what we're going to be watching now. So this is, well, live from Michigan. This is the lead prosecutor of the case. Don't know his name, but let's listen to him.
Those lines, and that very often goes into these decisions that, well, we could have done this differently. No case is absolutely perfect, but there are, minor things that may have happened, but there's nothing earth-shattering that's going to change how I present this case or what the facts are that come into the case. The second thing is, and like I said before, I think the jury selections are the biggest thing. I think I said before, and I'll say it again, I think we had a really good jury. These were very conscientious jurors. They were put in a unique situation. We've never had a situation where we've spent a week, almost 5 days, picking a jury where they're sitting alone, for days on end before they even start hearing the case. With that being said, they paid attention. They asked good questions. They were engaged that entire time. So this was a really good jury from my perspective. And I can't always say that. The questions they asked were, for the most part, on point when they're going through that process, and they spent a long time in deliberations. So they took this case, gave it the seriousness that it should have gotten. Now, I know some of the numbers have been out there. From my understanding, this did play a role in my decision making. It initially came out as 4-4-4, kind of a split. Not surprising, 4 for guilty, 4 for not guilty, and 4 kind of undecided. It did shift to 7-5. I think right about the time we got the first maybe we're hung kind of a response from the jury, and then it moved to 10-2 for not guilty. So that does play a role. And so with that being, I took a look at what is our history in our office in terms of doing a retrial. And quite frankly, we've had about 15 hung juries in the last 6 years, and we've only retried 1 in that 6-year period, and that was 11-1 for guilty. And looking at the facts of that case, it was a pretty overwhelming case, and so that's a case where you have a rogue juror. This was not a case with a rogue juror. I think this case, they paid attention. They did a lot to try and arrive at a verdict, and they couldn't arrive at a verdict. So then it goes back to, okay, what do I do differently? What can we do differently the next time we have this jury panel or to select a jury? I looked at what we did in the process. There were 43 strikes for cause. A lot of those were, they couldn't spend the time, they had conflicts, whatever it may be. But out of those, I recognize there were 15 that we said showed a bias to our case, at least in the process right there when we're questioning them. That didn't even reach. We had identified 30 before we even started selecting a jury of what I would term problematic jurors that I could say, geez, they're going to be a problem if we get them on the panel. They didn't make it into the jury box. So we then used 10 of our 12 peremptory challenges. I talked about this earlier where we cleaned out people that after they came forward and for whatever reason, for a variety of reasons, some of which had ties with the law enforcement, that we did everything we could. I can't eliminate everybody that has ties to law enforcement, because I've heard that out there is that, well, there's people on there that have ties to law enforcement. You're not going to eliminate everybody. That's not possible. So that's always going to be a factor. So what it boils down to is, I put the best case I could forward. When I tried this case, I did the best I could. I did everything I could. The jury couldn't reach a verdict. I still stand by the decision. I have, been involved in a number of officer-involved shooting cases or use of force cases. I've cleared most of them. This is one I thought should go to a jury. Have a jury decide based on, there's a substantial question of the reasonableness of his actions based on the totality of circumstances. We argued that, and the jury, a very good jury, was not able to reach a verdict. So I just don't see how, when you do your best you can, it comes in as good as you can. Generally, it's going to go worse the second time around, and I just don't see us being able to reach a verdict. I think you'll have the same, even if maybe we get some people on our on our side more in terms of, I think we'll just have the same amount maybe hung on the other side. I just don't see a place where we get 12 people to agree. This has split the community. I've heard over the last 2 weeks people passionately on both sides calling me, emailing me, advocating for and against a retrial. So that didn't play a role. I got to make this decision on my own. And looking at everything I had, looking at the facts, quite frankly, I felt there was not a basis to be able to retry this case and have a verdict at the end. So I made the decision to not do that.
Can you talk about the message this sends to the community?
Yeah, I don't know if there's any message. I'm not big on messages sending to the community. I mean, I think we try and make our decisions based on the facts and analysis, and in every case. I mean, I don't think this is, something that I'm trying to send a message by, charging them or not charging them. I made this decision based on the facts, based on the law, and what I thought I could prove. Like I said, I thought it went as good as it could have, but the jury it's always a jury decision, and you never know what his jury's going to do. But based on what I had, we had a very good jury, and I just don't see it coming to a different conclusion. So I don't know if there's a message there. It's I think to some extent the system works. I think this is a split community on this issue, and but I still trust in the jury system, and sometimes this happens.
What does this mean? What does this mean for sure? Is he a free man now? What does this mean for him?
There's, we're not proceeding any further. He's been free. He's been out on bond all this time. So he's gonna, we're just not gonna proceed. The case will essentially, be closed.
Did you consider reducing the charge and going for a conviction for voluntary manslaughter?
No, I thought about that, but I think that's kind of, that looks like I wasn't confident in my second degree. I think it was a second degree murder. And if the jury wanted to consider a lesser, I just didn't think that was, we were accused during the trial of trying to switch around what we're doing. And, that's what I thought it was at the start. I'm not going to change it just to maybe, okay, let's try a different way to get a guilty verdict. At the beginning, I thought it was a second degree murder, and I'm going to try it on that or not try it at all.
You talk about, have you spoken to the Leoya family?
I did. I spoke with Peter about a half hour, 45 minutes ago, and he's obviously very disappointed. This has been a very difficult case, and I apologize profusely. I'm very sorry I couldn't bring it to a conclusion for them. He said I lost a child, and he did, and I feel for them, and I feel for any family that loses a child in a homicide. So he's clearly not happy. I tried to explain it the best I could, but I don't think there's anything I could say that was going to make that he's going to be happy about it. And I understand that.
Chris, at the end, you said it was 10 jurors for not guilty. I just wanted
Correct.
to clarify that.
It was 10-2 was the final. That was my understanding of the final tally.
Thank you.
Can you walk us through, what have you been doing with this extra time? Why was this a decision you couldn't make on the day of? And what was going through your mind and thinking, there's a chance to bring this back? You knew on the day of this was a good jury. You knew the case you had presented. You knew the facts pretty well. Have you been going back and forth?
Yeah, I mean, this is serious. This is a big decision. I mean, obviously, this is a big decision, and this isn't something you just rush into saying, "Oh, we got a hung jury, so I'm going to forget about it." I mean, I want to make sure like I said, that's why I went through this process. I've never gone back and watched portions of a trial before to try and say, okay, is there something I missed? Is there something I got to do differently? When you're in the heat of a trial, you do miss things. And so did we screw up on the jury selection? Maybe, I thought it was a good jury. Did I miss something in that selection process? So, I knew the gravity of this decision. It has a big impact on the community, it has a big impact on, the Scher family, has a big impact on the Loyola family. So I didn't want to rush into it after, trials take a chunk out of you. It was a very, I spent a lot of time on this case. My office spent a lot of time on this case. Michigan State Police, they did a very nice job, and they spent a lot of time in this case. So it's not like I'm just going to, come up with a decision that at that moment I wanted to be thoughtful and consider everything I could, and that's why I took the time I did.
The jury foreperson, when they came in to announce they were hung, looked angry.
Mm-hmm.
Did you get a chance to talk with
Yeah,
her?
I think we asked about that last time. She said she kind of slipped in the chair, and she wasn't angry, mad. She kind of fell into the chair. So that's the response I got at the time. So that's all I can tell you. That's she kind of addressed that. She didn't appear to be that way.
What the holdouts were holding out for?
I don't know. We didn't, it's not, and that's the thing. It's, it's not we talked to every single juror. There was only certain jurors that wanted to talk to us. So, and we didn't, it's not like we tried to press them. I mean, so I wasn't involved in the deliberations to know, blow by blow. So I don't, didn't get that in depth.
So if Christopher Scher wanted his job back at the GRPD, they said he didn't violate training or policy. He's got nothing hanging over his head.
You'd have to ask the GRPD that. I don't know how they'd handle that. But obviously there's no criminal conviction. So yeah, and we're not seeking anything further.
Can you estimate on the cost of the trial between expert witnesses and security, and does that play a role?
No, cost did not play a role whatsoever. I mean, that's, we spent a lot on experts in terms of what the sheriff spent on security. I don't know that, that's outside of my budget. I know a part of our budget, we budgeted in for experts because we spent a substantial amount. I still haven't got the full, I think we're missing at least one of them, but we're probably $60,000, $70,000 just in experts.
The defense had mentioned that had this gone to another trial, they would have appealed or filed for the exclusion of certain evidence, particularly looking at like the police training. Did that play a decision at all, or did that play a role?
No, I mean it's been.
So there you have it. I think we don't need to listen because now it's just them asking questions. Let's see if they're still live even. yeah, no, they're not even live because so that was it. That is the decision on. Sorry, my patience today, it's not the best. I have a baby crying in the background because Garden Bot is changing the diaper, and I'm not even sure if he's doing correct. But there you have it. Christopher Shore is not going to be tried again. Charges have been dropped in that case. So that is the end of the case of that case. Yes, indeed. Shore is free, but no? Hang on, 1 second. There's bags underneath the buggy to put those plastic bags. So Christopher is gonna be a free man, but he's never truly gonna be free man. So I that's what I'm afraid of. So that's why I have to go check. But I hope he doesn't. It's definitely sure gets a chance of new life. He needs to move out of the area. He needs to go to another state to do something else. Like I don't think he should live in the same area anymore. I think that's probably a decision they're gonna have to do as a family. Obviously, me is just speculating and talking, but yeah, charges have been officially dropped against Christopher Shore in the case of Patrick Leoa. The jury was hung on the 10-2 or not guilty side on the trial, and yeah, that is and for that case. Sorry, 1 second. Sorry about that. So, yeah, sure, baby's all right. I think she's just fussing because Garden Bot woke her up for to change the diaper because she needed to. Yeah, definitely, and watch himself. Absolutely, absolutely. So, we've done a lot today. We've done a case prep for the Maxwell trial that is starting next week. We're gonna be following. We've watched the Rodney Hilton hearing that we have a date for the new trial of that case that we're going to be following, and we have watched the decision of the DA of dropping the charges against Christopher Shore. So it's been a very, very busy. I know I need to go check that. So I know it's probably a bit short of a stream normally than we are used to, but there's not really much going on. We are gonna go to the in-laws soon for dinner. So I think I'm gonna leave the trial. I'm gonna leave the live stream here for today. We are gonna be back tomorrow with more court, more stuff to watch, a lot more court hopping hearings. We'll figure that out what happens. And maybe Robert will be live. So make sure that you subscribe to her channel, click on her name, go give her some love. She might go live, she might not. We'll see. No pressure. She's amazing. She has bacon to cook for her husband and everything. But I've also done a video this morning with CEO about the Brian Koberger trial, so you can check that out meanwhile. And we'll see you in the True World Crime streets. So I'll see you guys tomorrow, if not before. Have a great afternoon, evening, morning, wherever you are in the world, and I'll see you tomorrow. Until then, have a great day.
And I'm a real-time crime professional.